Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi. And she yells, oh, girl, you gotta hear this one. A man was arrested for running the theme park. And when they said, where's your license? He said, my dog ate it. Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one. Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, you'll never guess what's true with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a prosecco, makes fun of all the weirdos, and then I hear her shout, girl, you gotta hear this one.
Hey everybody, happy Saturday. Welcome to the channel. I didn't stream yesterday because we have something special today. I have my little brother, aka my super mod, aka one of the best people on YouTube. If you don't know who he is, you really should figure it out because he's amazing. Flash fan.
Hello. Thanks for having me.
So before we get started, I just want to address two things. Hung Hero, thank you for the 20 Squid Pro Quo memberships. You are amazing, amazing, amazing. And I hope you and your wife are doing well. And Hung Hero, please give her a hug for me. And Hung Hero, thank you for the $5 super chat. And on the 69th day, of course, God said, turn the chat green. Okay. A little proverb for today to start the day. Someone is echoing. Okay, hold on. I gotta put my headphones in.
Yeah, it sounds like your audio is coming through a phone or not a speaker.
Yeah, it's through a different speaker. I gotta put my headphones in. Give me 1 second. I just hate wearing headphones because they hurt my, like, having brain surgery, things get funky real fast. So I don't, I try not to wear headphones if I don't have to, but sounds like I need to.
Nuances of YouTube streaming.
There we go. How's that?
I can hear you.
Is that better?
Yeah.
There we go. I know. Sometimes it's crazy. And sometimes I echo and sometimes I don't. And it's like, you can never really tell what's up with what. However, today we are getting into the Edrick Faust, or Georgia versus Edrick Faust cold case, the murder of Tara Baker, who was a law student at the University of Georgia who was tragically unalived in 2001. So, a little background on this case. A little background on this case. Baker was last seen alive at the UGA Law Library around 10 p.m. January 18th of 2021 or 2001. Excuse me, I cannot speak today. She was. It is my mic. Is it my mic or is it? Sure, it's. Is it me or is it Flash Fan at this point? Hold
Hey,
on, let me-
I can hear you, but it sounds like you're like in a different room.
Hold on, let me mute you and see if it's there. Now is it? Now do I have an echo? So I think it's Flash Fan. I think it's you.
Okay, hold on. I don't know how to fix that.
Hold on, let me.
If it is me. I don't. People saying that was
Let's try that. By muting Flash Fan, I fixed the echo, so it's him, not me. How's that?
That's technology for you.
Oh no, it's there again. Flash Fan, you broke it. Gail.
Probably. It's there again. I don't know how to fix this.
Do you have your Gabby asks if you have your volume on in YouTube?
Yeah, I can. Hold on.
Please stand by. Tech issue. Yeah.
Yeah, say I'm maxed all the way up.
That might be it. Turn yourself down a little bit and I'll turn you up.
Okay.
Are you listening to the stream on your iPad while you're and do you have headphones in? Oh, it's fixed? Okay, if it's fixed, it's fixed. Let's just go with that. Like, I don't know what happened, but it worked. So we're good. All right. So interestingly enough, or unfortunately, she was authorities believe she was strangled, poked with a sharp instrument, and assaulted in the no-no zone if you were talking to a child before her apartment or dorm room. I'm not really sure where she was living. Her apartment was set on fire. However, they believe she was still alive when the fire was set, which makes this even more god-awful. It's me. It's not me. It's because when I mute Flash Fan, it goes away. So I muted Flash Fan and it went away. So it's Flash Fan. It's not me. So it's Flash Fan. But how is it now? Hey, Amos girl. Yeah. So Flash Fan, I'll just keep you muted until you're talking, and then I'll just I think Gabby said I think he's watching it on his iPad. And that might be, you might have to mute your iPad. Try muting your iPad.
Okay, I turned it off. So on the other one, I didn't even have the volume up. So, but I turned it off. So I don't. Hopefully that.
Oh, there we go.
I don't know.
It's good now. Don't move. I can hear myself echoing. I just don't know where it's coming from.
Oh, it's not me because I turned off the iPad and I never had the volume. I don't know.
Okay. No, either way. Because when I mute you, I don't hear myself. So it's weird. All right. So basically, the fire was determined to be intentional and set in an effort to destroy evidence. And early investigative signs showed a stage stain, wiped surfaces, and tampering of doors and windows, and a detached bathtub drain. Weirdly enough. Well, Ashvin, I'm going to mute you while I'm talking, and then just Jeff says turn on noise cancellation.
I don't know how to do that.
Okay. I don't either. Let me go to your audio settings.
Let's see.
How's that? There we go. Can everybody hear me now? Oh, nope, I still hear it.
I don't know, cause I don't. Only thing you might hear is wind. And that's about it.
No, I can hear myself when you when I'm talking, but let me turn down my.
What's playing? I don't know.
There we go. Yeah, that's what I don't. That's the weird part right there. I mean, as if this is not a horrific. A detached bathroom drain just makes me go, huh? But the case went cold for 23 years. May of 2024, GBI, Georgia Bureau of Investigation, cold case unit arrested Faust after new DNA science and forensic testing linked him to the crime. The arrest was made possible into modern DNA technology, including improved testing capabilities not available in 2001. So he is charged with malice murder, multiple felony murder counts, burglary, rape, and aggravated sodomy, aggravated assault, arson, and possession of a sharp, pointy object during commission of a felony. All right. Flash fan, do you want to let us know what's happening with this trial in one?
All right, so the trial started Monday. It was opening statements. The state says that DNA evidence linked him to the crime, this Edrick Faust individual. And the defense say there's no evidence linking, and it seems like the defense is trying to point to an ex-boyfriend named Chris Milton. However, the defense hasn't filed a motion to get it before the jury, so there's been craziness with that. Also, they said that where's the notes? There was like the state said it was like 1 in 1 quadrillion matches the DNA that matches that links him up to the crime.
1 in 1 quadrillion?
One is it like 1 in 1 quadrillion? Hold on, let me go to my notes. I think this is okay. Let's see. It says
they're allowed to mention the boyfriend, but they're not allowed to mention any other randoms because they didn't file the motion. And we are going to get into a video, a clip that the defense is held in contempt. So we're going to play this video real quick. It's a 6-minute video. I have it on 1.5 speed because the judge does talk a little. I mean, it is Georgia. She talks a little Georgia, a little slow. That nice, sweet Southern accent. So, you know, Roy. And of course, Roy has to come in with these smart aleck comment. Good thing it didn't happen in Alabama since they all have the same DNA. I mean, and yes, we will make jokes on this channel. However, we are sensitive to the fact that a young woman, a law student, was tragically unalived. And although we are not a fan of this defense attorney for what will be obvious reasons, he is innocent until proven guilty. Disclaimer for the channel.
so okay. Oh, so the audio fits for for me now. So hopefully everything's good. But yeah, the district attorney said that one in 800 quadrillion. It's the odds that 1 in 800 quadrillion belongs to anybody else besides Edrick Faust.
Wow. That's a number that, like, I can't even fathom the amount of zeros that goes on that number. Like, I just can't even. All right, so we're going to play this defense held in contempt, and we are going to go through a couple of the documents. Because this is Georgia, this is Athens, Clarke County. It's the same county as quite a few other cases that we are currently covering on this channel. We do have access to the documents. However, I cannot download them and send them to anybody unless I pay for them. We can look at them for free online, but Georgia charges like $5 a page, and it's just Georgia charges an unbelievably exorbitant fees for their PDF version of their documents. So we're going to play this, and then we're going to go into another video and then a couple of documents. So just this is just what we're dealing with this defense attorney. And we all know that I hate the state, but when Flashman messages me and says, "You're going to hate this defense attorney," it's cringy.
Yeah, and for context, reading he was held in contempt it was questioning going on it was during opening statements, and they mentioned something. They mentioned assaults and stuff like that, and that they were going to challenge that, and apparently with a shield law violation, which apparently you can't use to impeach in most states unless the judge said, and she will probably say here, unless you file a motion and it has to be heard outside the presence of the jury, you have to get permission before you mention anything about it or present evidence.
Yeah, and Gail, we're balling on a budget here on this channel. I'm not paying $63 for another case that I'm covering in Athens, Clarke County is the NIL lawsuit with the University of Georgia, and one of the documents that they want $65 for a document. And I'm like, no. It makes Pacer look like child's play.
I know someone asked me about a case in California, and it was a document, and it was like $5 a page, but it's like 65-page motion. That's it.
Yeah. Georgia or Athens, Clarke County document charges makes Pacer fees look like child's play, but you can look at them online for free. So that's what we're going to do. But we're going to play this first because this judge is not having it with this defense attorney. And yeah. So here we go.
Action.
I do, Your Honor. Mr. Yalamanchili and I had talked in anticipation of us getting to this point over the weekend. I had made opening statement.
I'll pull that microphone towards you. Thank you.
That I would object since I had made the opening statement, but since Mr. Yalamanchili had made the 412 arguments in the past that he would handle.
All right. Thank you. Go ahead, sir.
Your Honor, as the court's aware, as the state's aware, if Mr. Cruz wasn't aware before we started all the pretrial motions in this case, he ought to be aware now. Making reference, whether it's a state.
And just for reference, Mr. Cruz is the defense attorney.
Yeah.
Just so we're aware, Mr. Cruz is the defense attorney. The defendant is in the plaid button-up shirt.
Yeah.
Statement made by some other witness, whether it's elicited in direct examination, cross-examination, or any other method to a relationship between Ms. Baker and anyone else that was not noticed by the defense as a 412 act is prohibited by 24-4-412. I'm not sure how much clearer the statutory language could be. I'm not sure how much clearer the court could possibly have been in its instructions. But whether it's Mr. Cruz making reference to a statement that some witness made during an interview with law enforcement, or whether it's Mr. Cruz eliciting the testimony on direct examination or cross-examination, it is all prohibited by the rule, which Mr. Cruz has violated now for the second time in his opening statement. It does not matter. It does not matter one bit whether or not Chris Melton said that in an interview to law enforcement for the analysis of whether or not it is admissible and the methods that must be adhered to if the defense intends to admit it in any way, shape, or form. Judge. And so this is the second time before we've called the first witness to the witness stand that Mr. Cruz has violated 412 in what seems at this point to be an intentional pattern to try to work his way around the laws and rules of the state of Georgia as it relates to admissible evidence in cases involving allegations of rape and aggravated sodomy, Your Honor. So
It's not very often that you hear someone charged with sodomy. Not very often does that actually get charged. So that's a new one.
Yeah, he's charged with 12 count, 11, even 11 or 12 counts. So he's charged with a lot of stuff.
Yeah, I'm looking up the documents right now. I just had to scroll through because this defendant, this crime, it's not an alleged crime. It's an actual crime, just an alleged defendant. This alleged perpetrator has a long history and a long rap sheet and has been in front of this exact judge multiple times. So it's a, but the interesting thing is all of the cases that I can find are after 2001, which makes me think that if he did commit this crime, that maybe it psychologically broke him and he got into, the booger sugar or Florida snow, as somebody called it. The only snow you see in Florida is
On Thursday, the state tried to present a mugshot. He was arrested February 6th or February 8th of 2001, and they wanted to present a mugshot. Cruz objected, and it rightfully got sustained because he was like, that would prejudice the jury, that would prejudice the defendant. You show it to the jury, that implies guilt. So they flashed it in front. They put his mugshot up to show it with a picture of him, or to insinuate that it was a picture of him, but they didn't say what it was. So
what is interesting is everything that has been filed in Athens, Clarke County. I have not looked elsewhere. I don't know, but everything that I can find on this defendant in Athens, Clarke County was filed after 2001. So I'm just curious if he did hypothetically commit this crime, because me, I'm into like the psychology of things, like why people do things. And if he did commit this and then got away with it, if he could not psychologically handle the fact that he did it, and that led him down a road to commit other crimes. This is the way my brain thinks. I'm weird. Like I'm just weird. But this is the way my brain works, and it's weird like that. But I cannot find anything that I've been able to search for prior to January 2001, which is interesting if you're the state to bring up, in the sense of, well, he's committed all these crimes because he got away with this and couldn't psychologically handle the fact that he did this and it broke him. Or you see where I'm going with that? Like it's just weird.
There's definitely some weird stuff in this case. If you watch it closely from like the 5 days, the evidence, the forensic evidence, it doesn't really link anybody. It doesn't really link this guy to him. And it was even testimony of that it was another hair sample found that didn't match the boyfriend or Edrick Faust. So
yeah, and Heidel, PSA, this case is grossly dark and is horrific. Guard your mental health. If you need to step away, break, or mute for a minute, please do so. Yes, this is
brutal. Yeah.
Yes. However, cold cases are very interesting with the science of DNA and what is allowed in court, because what's happening here and the new DNA technology is kind of some of the same stuff that's happening in Tyler Robinson's case, where they're using DNA technology that's never been used in court before. So it's kind of a thing. Hey, Ronnie, how are you?
Hey, Ronnie.
So it's interesting in multiple ways, but it's also from the family's perspective. Will they get justice? And is this truly? It's weird. It's what makes it fascinating.
Yeah,
Because you want
cold case is fascinating because I'm like, what do y'all have after all these years? What did you find that caused you to think that this guy did it? Because if you believe the state and the defense, because like I said, it doesn't seem like they didn't know each other, so I'm like, this would be a seemingly random attack. What would he do it for?
yeah. And random attacks are generally the hardest cases to solve because you don't know, like the people don't know each other. It's like it's just
And if
but I
you look
had
at
seen
the
it.
crime scene, if you look at the crime scene or read about the crime scene, it's brutal. I don't know what's YouTube friendly, but yeah, it's like it shows like it's like a crime of passion, like a rage attack. So I'm like, why? They didn't know each other.
Yeah, it's just certain things that are odd, but also well, technically speaking, Laken Riley and Jose Ibarra didn't know each other either.
Yeah.
So pick your poison with this one. But that's what makes, and see, to me, that's what makes like psychology so fascinating is why behind what makes people tick. It's fascinating to me. But also, it's just sad for the family because this could have been the lawyer that, like, you know, I don't know, save. Yeah, could have been, the next president. You know, it's,
I wanted to like the defense so bad. I really did.
you know me. The more trials I watch, the more more anarchist I become. I hate the state because the state and the judge are technically on the same team. They
Yeah.
both get paid by the same body of money. However,
And it doesn't help that this prosecutor is the actual elected district attorney. So I'm like, okay, are you doing this
and
for political reasons?
that's true too. And also, but also, like the defense attorneys that have been in cases that have been televised or streamed on Law and Crime and Court TV lately have just been like, ick.
Yeah.
Like,
The first
ick.
good one we had so far is the Tyler Robinson defense attorneys. I like those attorneys.
Yeah, and they're just frustrating because they're doing everything they can to stall. I understand that's their job, but like they're just but some of the lawyers that we've seen lately are like, this is why people hate lawyers. You right here are why people hate lawyers. Like, all right. We're gonna get back into this.
So again, at this point, I don't know what the remedy is that the court wants to enact, but obviously telling Mr. Cruz not to do it isn't effective because he's not listening and he's not following the court's orders.
Thank you. Cruz, any response?
Absolutely. I'm actually blown away and in shock that the state is taking this statement to be a 412 argument. Our theory of this case is that Chris Melton committed this crime. Chris Melton's statement, when he's confronting DNA that he already knew was present, that she was with someone else had, it has nothing to do with us trying to get around Chris Melton. That statement is for the sole purpose of showing his consciousness of guilt. He knew this information in 2001. He showed the exact same information in 2024. And his response isn't, oh, my girlfriend, I can't believe this happened, you guys better find her. His response is just simply to say, oh, well, let's leave. I mean, she was with somebody else. There's no evidence that I intend to present that Chris Melton knows about Ms. Baker's sexual history. There's nothing I can intimate that Ms. Baker knows, that Mr. Melton knows about Ms. Baker's sexual history. The purpose of that statement has nothing to do with her character, with her 24/12 sexual character. The purpose of that statement is to show Chris Melton's response. When he's presented with some evidence, he gives a response that's inconsistent with the person that is innocent. So this isn't a 412. I understand the state may not like what I present, but that does not mean I have to preview every single statement I have to them so they can prepare their case. This is open statement. I respect where I do anything for this word. I told you that multiple times. This is not a 412 argument. This is Chris Melton, who knows nothing about Ms. Baker's sexual history, being confronted with a piece of evidence and making a statement that shows consciousness of guilt in our. This has nothing to do with sex.
All right, thank you. As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you. You have been told many times that in order to present
That right there. He tried to interrupt the judge. He tried to interrupt the judge. And like, I don't know. This is one of those situations of like, stay in your lane. The judge might be completely off base. The judge might be completely wrong in her opinion. But the one thing you don't do is interrupt a judge. And I know I interrupt people all the time, and I am awful. I am awful. However, that being said, I would never interrupt a damn judge. Interrupting a judge is like interrupting a cop. You just let them talk. They might say shit that you do not like, you do not care. Like it has nothing to do with you, is not important, is way off base, but you just let them talk. Let them finish their thought, and then you talk.
And this is my problem with Cruz. He asked for a mistrial every 15 minutes. It'll be denied. 15 minutes later, he'll come back and ask for a mistrial. It'll be denied again. I'm like, if you really have great concerns, is this really how you say it is? And sometimes I agree with him, because sometimes some of the rulings she mean like, that's a bit of a stretch. But if you have an issue, just file it on appeal if it get there. You know she's gonna deny it.
Exactly. Well, there's two things that you and I always talk about. Like you're never going to get something go your way all the time. A judge is never going to rule in your favor all the time. If you see a judge that rules in one person's favor all the time, that judge is biased.
Yep.
Because nothing goes a certain defendant or a certain plaintiff's favor all the time. It's just not the way shit works. And with that being said, you still let them talk because the judge gets it on the record, and then you have it for appellate reasons. If you interrupt the judge, you don't let them finish their thought, which might be completely wrong and off base, but that's your appellate. Like that's your appeal. Plus, you just never piss off a judge because you just really don't want to piss off a judge. But I know you don't follow a certain other case. However, two people brought it up. Roy said he's a graduate of the Matskin School of Law, and I have a problem with doing this. And
I do know that name. They had no enough to know that name.
Yeah, you know that name. And she Nemesis said, sounds like something another lawyer in another case would do. Yeah, y'all both, and James, or that side is so passive they only argue what they know will win. Well, that's true too. That's a good point. It's just you just don't interrupt a judge. Just some things you don't do.
We
Like,
saw
I was
how
talking-
it went Rittenhouse.
Oh my god. Oh, we're not even gonna go there because God forbid. Yeah. Mm-mm. Papa Squid lives near that area, and that prosecutor ran for district attorney in another county. Did not go well. Yeah.
Yeah, that's fair enough.
So I did find the document for recusal. So we have that.
Yeah, because there's some, and if y'all see, I think Squid told us she's gonna play a couple of clips. They have animosity towards each other, including the judge. That's because he filed a motion like a week or two before trial started to remove the judge, and she said no. And then I think it's either Supreme Court or somebody else, the higher judge said no. She judged it early. So
And we'll get into the documents, but just know I did see them. I just can't open them up because I can't open it up right away because then I can't open up any other document or see.
Oh yeah, no, you
So,
good. I was just explaining to them like
it's just
the animosity between and that's why because he tried to
oh,
get
this judge does not like this defense attorney. Does not. And I really don't blame her because sometimes I'm like, even when he does make a good argument, he just doesn't know when to stop.
Yeah.
Like, make your argument, and then when you have a point, that's when you stop.
He's
I don't.
like James Owens in that regard.
And for those of you who don't know, James Owens was Sarah Boone's trial lawyer. All right, we'll get this started again. We're almost
Statements
done.
like that, ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it, even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412. And it is not appropriate. I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm finding you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders.
Yeah, basically, so you've been sanctioned.
$1,000.
$1,000.
That's not steep. That's a big fine.
Yeah. So this judge has been not having it with this attorney. There's a video put up by Law and Crime that's titled "Top Moments of Tension Flared Between Edrick Faust Defense and Judge."
Yeah.
Like this is
And you're gonna see equipment here that he compares the trial to something, and yeah. Good luck.
oh my god. Yeah, so we're gonna watch this one. Let's go back to the media.
And he asked for stuff.
Yeah, the mistrial, like I understand it's common procedure, and basically between when the state rests before the defense, they always ask for they will always say that the state didn't meet their burden and ask for an acquittal.
Yeah.
And it's like there's things that always happen in trials. That's like, it's just a procedural, like every defense attorney will ask for it. However, that being said, do not ask. I'm not a lawyer by any means. God forbid am I a lawyer. You will hear Flash fan joke about Judge Squid. Hell to the no, because that means I have to be a lawyer. However, with that being said, Rhinestone Wall Girl, how are you? And Hill on Top. Hi, Squid. How are you? Oh, and SMN, thanks for the $10 super chat. Everyone, pray for snow just for Squid's house in Georgia. Shovel fund. It did snow here like an inch, and it was gone 2 days later.
I said when you said it snow, I'm like, yeah, I believe that one don't.
I sent you a picture.
Yeah, I know she did. But no, what I don't like about Cruz is what she'll do is before the jury comes out, she'll be like, okay, anything further from the state? No, anything, Mr. Cruz? No, no, ma'am. They bring the jury in. The witness get on the stand. They'll ask questions. Your Honor, I have a motion outside the presence of the jury. I'm like, why did you just say that 5 seconds ago? Before the jury came up.
We have, it's just, it's one of those, like, he knows what gets under her skin and he's doing it just to which is funny when it's like YouTube or when it's like personal relationships, when you have someone who tries to bully you and you know what gets under their skin, so you keep doing it because you know it pisses them off. That is not a judge-lawyer situation.
This is the one person I want to mess up, because if your client gets found guilty, you could potentially argue for a lighter sentence. If you make her irritated all the time, she's gonna sentence him to life in prison without the possibility of parole.
Like I know that I antagonize certain people in the world. However, I have never antagonized purposely a cop, a judge, somebody at the DMV. Like there are people, a waiter or a waitress or a waiter or anybody who's serving me food. There are certain people in the world that you do not piss off on purpose.
Especially since there's a bunch of food poisoning cases out there.
Well, yeah, true. But like there are certain people in the world where you have a certain level of decorum and courtroom decorum, whether you like the person or not. You have a certain level of decorum. Maybe I learned this working with patients who literally told me to F off every 5 seconds, like who told me I was the worst thing that happened to the fucking human race and that my mom should have swallowed me. Like,
Wow.
you know, I've been called the spawn of Satan and been blessed by a nun in the same day, within hours of each other. Like,
wow.
one of my patients was a nun and blessed me. And I had another patient who was schizophrenic and called me the spawn of Satan, among other things. The spawn of Satan is just the YouTube friendly version in what I can remember.
Yeesh.
But there are just certain people in the world that you don't antagonize. A cop and a judge
Oh,
are
yeah.
2 people on that list. Just the decorum. Like I don't have to like somebody to be respectful of the position. Like I don't have to like a position to realize that somebody got there for a reason.
And it's all right
You
to call
know,
them. It's all right to call judges out, but don't do it and continue to argue. When she said, "Okay, oh,
yeah, you can tell her she's wrong. You can push back a little bit, but when the judge puts up a boundary, don't jump over that boundary like you're damn in the 100-meter hurdles in the Olympics. Like, yeah, Tammy's like, it's a normal day that ends in Y in healthcare. Yeah, pretty much. Yeah, I don't, you know, too.
It's just some jobs I could never do." That's wow. I'm a patient person, a cool, calm, and collected person, but I don't even know what I can think of all that.
But that's how you learn to deal with difficult personalities. And because you have to work with those people, whether you want to or not, and whether they want you to or not. So you figure out how to deal with difficult personalities. And there are just some people you don't antagonize. And you learn to meet people where they are. And the judge is not somebody I'm antagonizing.
Oh no.
Yeah, don't just keep going on and on and on and on. Gail, I feel like that's directed towards me. So we're gonna get into this. Yes, Flash Fan is a cool customer. Yes, exactly.
It's only real.
Flash Fan. But if Flash Fan ever asks you if you want to eat or if you like fried tarantulas, just say no. Just say
That's
no.
how I first found her on YouTube, and Mo said, "Like, do you eat deep fried tarantulas?" Her response, like, "No, what is wrong
Just say no." Yeah, my first interaction with Flash Fan was in Mo's chat. And it was, dude, what is wrong with you?
And the rest is
And here we are.
two, almost 3 years later.
Just say no. All right. I'm going to get into this and then I have to go do something real quick. So I will be right back. So I'm going to let this play.
Y'all may be seated. Yes, sir.
And I'm moving for a mistrial. We raised a objection to lack of foundation. The case is Monroe v. State, 340, Georgia Appeal, 373, 2017. It provides that the Honorable Court has wide latitude to admit demonstrative evidence, and the burden is on the party offering demonstrative evidence to lay a proper foundation establishing a similarity of circumstances and conditions. Although the conditions of the demonstration need not be identical to the event at issue, they must be so nearly the same in substantial particulars as to afford a fair comparison in respect to the particular issue in which the demonstrative evidence is directed. Further, experimental or demonstrative evidence, like any evidence offered at trial, should be excluded if it's probative value and the case goes on. But we emphasize the language that we stated. Your Honor, we raised a lack of foundation objection. Your Honor alleviated the state of their burden to prove any type of substantiality between the tests that Mr. Agent Grove, is that correct? Engineer Grove conducted and allowed the state to introduce this demonstrative. Once the bail is wrong with the jury, it cannot be unwrong. As we've said throughout this trial, Mr. Faust's defense has been handcuffed. The state has had free reign. It's to the point where our objections aren't even acknowledged. So, Your Honor, based on Mr. Faust's due process rights, violation of Mr. Faust's due process rights, in the entry of this exhibit, we would ask that the honorable court grant our motion for mistrial.
Thank you. Mr. Yalman, any response?
Oh, the mistrials. Oh, the mistrials.
Yeah, there's like 15. I think it's like day 1 or 2. There's like 15 mistrials that the same day.
Sorry, I just had to go real quick. The little is on the big girl stuff, you know. Mr. Squid is home and taking care of it, but also she left her iPad on in the room I'm in and left the room, and she took my lunch.
Oh wow!
So this is because we're on Squid's weight loss plan, which is I have not eaten breakfast yet today because I went to the gym this morning, so I'm breaking my fast with a protein shake. So had to take care of a lot of stuff.
My aunt told me, she's like, you should fast. They do like 21 days of fasting, and she's like, you should fast. I'm like, not eat for 21 days. I said, I can't do it. I'm sorry.
You not? Well, I don't. We're not doing like extended fasts. We're doing like not eat after dinner at like 5 o'clock. We eat dinner at like 5 o'clock. Not eat after dinner, and not.
Water.
We're doing like 16 hours. Just enough to get some fat burning, give your digestive system a break, let your hormones kind of regulate, let the insulin let your body become sensitive to insulin and not resistant to it, and all that stuff. However, Bobby, spiders are friends. We have Spidergate at my house. Where have you been? I've missed you very, very much, but you have missed Spidergate. We have brown widows at my house. And black widows at my house. There's a black widow. They found a black widow in the backyard too. However, yeah, I do intermittent fasting. I either don't eat. I don't eat after dinner, and I don't eat breakfast until like 10 or 11. So, yeah, don't get me started. Yes. So, but I break my stuff with some protein, and because I'm not out where I can cook eggs and have like sausage or bacon and my protein bread, I'm breaking it with a protein shake. So let's see what the state's response is. And I have not been able to watch this entire stream or this entire case. I've hit highlights here and there, hopped into a Flash Fan stream on Discord, and Flash Fan is streaming this on Discord. Flash Fan, do you want to tell them when you are streaming and put your Discord link?
So we stream. It happens Monday through Friday when the trial is in session. So Court Watch was originally set up for classic cases from the 90s, Menendez, stuff like that. O.J. Simpson, even though that's a long case, probably won't do that one. But so I have started doing newer cases because people were just interested, and I'm like, yeah, I'll do it throughout the day. So the trial happens Monday through Friday. I start at 11 p.m. Eastern Standard Time so to get through the breaks. And the defense saying that the way they're going, I believe them because they have all these motions. They say the trial could last anywhere from 4 to 6 weeks. The judge says she don't think it's gonna happen, but I'm like, yeah, with the way y'all going, it's gonna be 4 to 6 weeks. So either 2 weeks, either this will be the last week, or we got about 4 more weeks left. And we usually
originally I was like
5 p.m. Eastern time.
Originally, I was like, how is this going to be 4 to 6 weeks? And then I was like, what? What? But I told Flashman he doesn't need to start a YouTube channel, and because he would be amazing at it, with the amount that he takes over everybody else's YouTube channels. I mean that in the best way possible,
I can say
not in a bad way. Hey, T3 is here, talking trash and truth. How are you doing? Oh, I appreciate you so much. Oh. All right, we are going to get back into this because this is just I've seen some defense attorneys where I'm like, why? But this guy is just on another level. This
Crazy
is
part,
Daryl Brooks.
he won me. He hooked me. And then I heard some of his questions, I'm like, oh, and some of his motion argument, I'm like, oh man, okay.
This is Daryl Brooks level lawyering right here. Like I just can't. Did he get his law degree out of a Cracker Jack box? Yeah.
And apparently his website says he's known for getting dismissals. I'm like, how?
because judges don't want to deal with him. Maybe that's Bruce's problem too, or maybe that's Bruce's success. Hey, everybody here who follows the craziness out of Florida and Levy County and all that stuff. Maybe that is where Bruce has been successful in the past, is judges just don't want to deal with him. So they say, fine, whatever you want, just get out of my face. Flashman was a blast on AJ's the other day.
It was great. It was frustrating.
Like I said, like I could come on, Flashman. This is peer pressure. Peer pressure from me in the chat.
Take Colt, watch the YouTube.
You've got it. If you can run Discord, if you can do it on Discord, you can do it on YouTube. Like, because Discord, I'm still like, if it wasn't for you and Gabby, I wouldn't have a Discord server because I'm still like, Discord what? Like, what? Yeah. Anyway, we'll get back into this.
Thanks, Gabby.
Your Honor, the foundation for the admission of the exhibit was laid. We haven't gotten to any of the questions as far as, what testing was done by Mr. Grove. We went through his qualifications. So one, the motion is untimely, but even fast forwarding for the purposes of, and I would just note for the record, the only thing that's been displayed to the jury is a picture of the exterior of 160 Font Drive. So, but just fast forwarding a little bit, Your Honor, Mr. Grove received information. He tested certain things that were part of the theory as far as how the fire began in this case, and those are contained in the report. I would also note for the record that Mr. Cruz had an opportunity to review this PowerPoint last night in its entirety. He did not raise any kind of issue with the court prior to bringing the jury in. It's certainly, one, it's not even improper, but two, it's not grounds for
Mr. Cruz, you got Mr. Cruz. I'm going to let you respond because it's your motion, but you need to let Mr. Yalamanchili finish his statements. Go ahead, sir.
I said that the evidence is not improper. I am making no personal attack on Mr. Cruz, but additionally, there are no grounds whatsoever for a mistrial based on this, which is properly authenticated and admitted evidence as a demonstrative aid, Judge.
All right, thank you. Mr. Cruz, anything further?
Absolutely, Your Honor. The Honorable Court, at the conclusion of court, allowed us the opportunity to view this demonstrative. The state, in multiple arguments, has insinuated that I have to run everything by them and then run it by the court. The law is the law. Regardless of how Mr. Yalamanchili feels about me, the law is the law. This isn't anything personal. We're advocating. He says Mr. Faust did it. I say Mr. Faust is innocent. This should not be admitted without laying a proper foundation. It is admitted without a foundation. He's saying, hey, Your Honor, we're going to go through the questioning while we're showing the jury what the exhibit is. That's not the law, Your Honor. The law says that before they could present demonstrative evidence, they have to lay the proper foundation. That was not laid. The Honorable Court admitted it without even hearing us out on just denying our objection. So, Your Honor, Mr. Faust is not receiving
Here
his due
comes.
process rights. I am requesting a mistrial.
Thank you, sir. All right. So first, I just want to respond, Mr. Cruz, to your comment that the
Okay, before the judge starts, like I know that we Flash fan, I know that you are a super sweetheart and you would never do this, but this is where my old age and don't and filterless and beyond caring. If I were doing this at night and I were streaming this trial, I would have a drinking game of every time he says mistrial, you take a drink. And I'd wonder who would survive by the end of the night.
You would survive that one. Do like how recovery addict do. Recovery addict when he stream chart, he do like counters, like sometimes like objection counters. How many objections?
Yeah, the objection counter. But I feel like we need to do like a mistrial or like a objection mistrial or mistrial counter. Gail, I haven't had a drink all year, so like I don't, I wouldn't do that anymore. But I'm just like, you know what I mean? But Tammy says, Flash fan, go for it. You will have a cheerleader in your corner with Squid. Yes, you will. Because Flash fan is my biggest cheerleader. So I am his.
I appreciate
Because
it.
who else in the world will just send text to people, just says, you are awesome, have a good day? Flash fan. Flash fan is that kind of person. He is probably the best person, the sweetest person on YouTube. Just saying. I love you all, but like Flash fan's amazing. And I know I just made you blush, so we'll start this so you can get your wits back about you. Flash fan, you always make me laugh. I love it. I miss streaming with you. We need to do this more often. Like, yeah, it doesn't have to be alcohol. Look at everything Jeff consumed. Yes, Flash is amazeballs. Look at all this. Look at all this. Look at this. Flash is one of the sweetest, most thoughtful young men around. Heck yes.
I appreciate y'all. Y'all trying to make a brother cry on stream.
Flash fan's screen is glowing red. All right, let's get back into this so Flash fan can get his wits back about him. Because I messaged him on Monday and I said, hey, have you heard about this trial? And he's like, yeah, I'm going to stream it on my Discord. And I was like, I just heard about that. Like I opened up YouTube and this popped up and I was like, how did I not hear about this
And I'm
sooner?
surprised you were going to do it because I know you're not a big fan of covering Georgia cases. I'm like, oh, really?
Well, it's one of those things where it's a cold case and it's like it's
many
just
years ago, it's not recent.
Plus, it's a law student, so it was like even more fascinating. Plus, it's Athens, Clark County, which is the same county as Lake and Riley. It's the same county as the NIL stuff.
That's why this district attorney is prosecuting the case. We had a female. It was a female district attorney, Deborah Gonzalez, but she lost in December 2024 because she didn't want to prosecute a bar.
Oh,
and this dude beat her decisively. Yama Michelli, or however you pronounce his name.
Yeah, and I was thinking originally before I had actually seen this, seen the prosecutor and stuff like that, and just looking at the judge, I was thinking, are they going to try to pull? Is this lawyer going to try to pull the race card and say that And I'm not looking at the district attorney, and I'm like, that wouldn't work.
He didn't, but if you look at Cruz's opening statement, he did mention something like that.
And I'm just like, what angle are they going to choose? And I'm like, I just.
The defense is trying to present that Chris Milton, the boyfriend, did it, but he can't file the appropriate motion, so I don't know if that's going to be able to work.
Yeah, and you would think if they were trying to, and this is what was another fascinating point where I'm just like, this is not just bad lawyering. This is like, do you really believe what you're saying? Because if you really believed what you were saying and you knew you had to file that motion because the judge literally told you before she sanctioned your butt, you would file that motion like immediately. You would have your co-counsel leave the room and start writing that shit. Like,
And that's another thing. He has co-counsel, but he does all the questioning and all the arguing. I'm like, what's your co-counsel there for? We only
Why
hit
did
this
it
guy.
why did it take hey AT1, why did it take 2 decades to get this person to court? DNA testing.
Yeah, DNA testing, and they weren't really looking at investigating cold cases. Something called the Coleman-Baker Act was passed in Georgia. I don't know I know what the Baker referred to. I don't know who Coleman is, but that would get them started looking into it.
And having moved down here from another state, they are very they seem to be very interested, and GBI seems to be, from what I've seen, just based on personal knowledge and hearing things in the news, because I live here. They are very interested in current cases and making sure that they have a very high prosecution rate on, hey, this happened, we're going to try to find. But cold cases seem to be not as. This is the first time I've ever heard about a cold case being investigated, let alone prosecuted.
Yeah, that Coleman
In the 5 years I've lived here.
it cost the GBI that Coleman-Baker Act when the governor, I think he was the governor or mayor, passed it. It caused the GBI started opening up and re-looking into all these cold cases, and that's how they got DNA testing for this case. And how it led to Edrick Faust, I don't know, but apparently it did. So they got a suspect in May 2024.
Well, also, he's got all his, because he's been arrested so many times, his DNA is in the system.
Yeah.
So if they are going to test DNA, the first thing they're going to do is test it against people who are already in the system.
Yep. See who comes back with a match.
Oh, and FYI, do you know where they go after they test everybody in the system, in the criminal justice system? Do you know where they go next to test DNA? Ancestry.com, 23andMe, all of those databases. So, yeah. Why is mine so low? Probably because I have mine turned down because I was echoing earlier, and I just turned it down just to.
Yeah, it seemed to be working fine now because you come through quickly. But it's we had issues earlier.
Right. Someone watched the old cold case series on CBS, saw them and solved decades old cases in 1 hour and said, we can do this.
They also had one in Massachusetts. I don't think they're gonna stream it, but I hope they do. They got a cold case from 1986. I'm like, if they having trouble here, I don't even want to imagine what they're gonna have trouble trying to solve a 1986 case.
So all those DNA programs, what's interesting is they've actually found there is genetic genealogists who will actually help police solve cold cases, because someone will put their DNA in that system testing their ancestry, and it will link to a case. But it is not the person who put their DNA in the system. It is their parent, their uncle, their cousin. It is a relation to the person who put their DNA in the system.
And maybe that guy, they would immediately test him because he was already serving 20+ year sentence for attempted unalivenment. So
it's crazy, but it's like, welcome to 2026. Like
I like you do all the teen cases, and I love watching all the cold cases. This stuff fascinating.
Yeah, I got a knack for the kids who unalive their parents.
There's something going on in North Carolina where they're the sentencing, but it's kind of like a trial where I think the guy's like 18, 17.
Oh, and we also have to get into all the 764 and Order of 98. Those cases are coming back, and some stuff. Now that someone's not a assistant FBI director, he is posting back on his podcast, and he has mentioned it, and I'm hoping to get some information. So,
maybe an interview coming up.
Hey, Harry, we're Georgia, not Alabama. Come on.
Georgia. Oh, wow.
Yeah. Oh, Talking Trash and Truth. Thanks for becoming a new YouTube member. Oh my God. I feel so privileged to be doing what I'm doing. Like the fact that anybody is even here. There's 25 of you here. I appreciate it. I wish we could get the numbers in these streams that we get for the drama streams.
Yeah, like where are the
beca-
300, 400 people?
Well, I never get 300 to 400 people anymore because that's what happens when you piss off too many people. But Yalaman Chili.
Yeah.
Okay. I would have never got that from the hearing it. Yeah, me neither.
I was mixed between Yamamachili or Yamamachili. Yeah, this is a good term here.
Yalaman Chili.
Yeah.
Yeah. All right. We will start this. Okay.
Defense is hamstrung, that the state has free reign. It is unfortunate that you are, as an attorney in this case, responding to the court's rulings in that way. The court certainly endeavors in every way possible to make rulings according to law. And it is unfortunate that you feel otherwise. That being said, you have asked for a mistrial. I'm denying that motion. There are no grounds for a mistrial whatsoever in this particular moment. This is a demonstrative aid. It has been admitted into evidence, but demonstrative aids do not go back to the jury. The state is correct. They did provide you the opportunity to see that demonstrative aid. They did not have to do that, but they did. You are mischaracterizing the court's rulings, Mr. Cruz, in suggesting that this court is somehow forcing you to show the state your hand without making them do that. That doesn't fit any of the scenarios in this case so far. And that is a mischaracterization that is pretty frustrating for the court to hear. There are no grounds for a mistrial. The state has properly authenticated this particular aid, and the foundation has been laid. There has been no violation of 403. I find that this moment has not even suggested that 403 is even in jeopardy. And I'm making a finding again that the evidence is at this point not improper. This is a demonstrative aid, and I'm denying your motion. You may bring the jury out.
Yes, ma'am.
You all may be seated. Yes, sir.
Your Honor, I am again moving for a mistrial. We can't impeach witnesses. We
Pay
can't.
attention
Hold
to this
on.
one.
Hold on. So, Haley, Alexa, find a recipe for Yalaman chili. Oh my god.
Yo, man, chili.
God, that's so bad. I should not be laughing at that, but that's where dark humor and sarcasm and the fact that we can laugh at ourselves.
You need it with these type of cases too.
You do. Yeah, this judge is pissed. Yeah. Well, runs around the room. Get him, judge. Get him.
And also,
Yeah.
this clip that's about to be playing, pay attention to what I'm not gonna say what he said, but pay attention to what Cruz says here, because I believe this is the clip.
Argue consent. The state can present things that we can't present. We can't rebut allegations in their indictment. We are requesting a mistrial. This is not fair. This trial has been worse than practicing in communist Russia.
There
He
it
doesn't
is.
stand a chance in this courtroom, Your Honor. The witness made a prior statement. We played the recording for the court. The witness made
There it
Hey,
is.
Shani, how are you? And we're just going over highlights. And after we get through this video of the tensions between when the between the judge and the defense attorney, we're going to go through some documents because I do have access to all the documents on Athens Clark County's website. I'm getting very familiar with that website because I'm covering like 5 cases on there. However, I have access to some of them, but I can't like send them to people because I have to pay for them if I download them. And Georgia's like $5 a page.
Yeah.
Like,
Hey, it's the South.
but it's good to see you. Yeah, we have to laugh with cases this dark. Lawyers this surprising. Yeah, yep. He compared this trial to communist Russia.
Yep. When I heard
And
that, when I first heard that, I'm like, nah, I'm tripping. And people, Ronnie and Haley within Disco, were like, nah, I think he said like, nah. I had to run that back, like, oh, I'm that tripping.
the prior statement. He was wearing like an orange colored shirt, orange or red, something bright. That is a quote. We played the recording. The Honorable Court was able to hear that recording. Her testimony here today was that he was wearing a hoodie. This is important because the state wants to make all the people that were seen in the neighborhood Mr. Faust. The person that they brought, the first witness, EM4, said, oh, he had a jacket. So, of course, they want her to say, oh, he had on a hoodie. It's an inconsistent statement. We are handcuffed, Your Honor. We are asking for a mistrial in this case.
Thank you.
And someone brought this up before, but someone brought this up, I believe, yesterday when we were watching the Daubert hearing, that a hoodie is a type of shirt.
Yeah.
So if they said red shirt and red hoodie, a hoodie is a type of shirt. Like this is a type of shirt.
Yeah, he getting so mad over this issue. I'm like, really over a bit stuff between a hoodie and a shirt?
Like this is a and Shani, this judge is horrible. You can so tell the state is paying her. Well, the state's paying her because
I gotta say, there's people who said that there people who agree that the judge didn't treat Cruz fair, that she is being biased. I don't see it personally, but maybe. Like I said, I don't know. I'm not a lawyer. I can't speak to the rulings.
well, I would just be annoyed with her or with him if I brought the jury. I asked, like you had said earlier, if I asked, does the state have anything? Does the defense have anything before I bring the jury in? You bring the jury in, you take the time. When she had said in the first day of the trial, when they said 6 weeks, and she's like, I'm not going to waste any time. And you take the 20 minutes to get the jury in, seated, ask them questions, and then the minute that you start, he's like, I want to discuss a motion outside the presence of the jury. And it's like, I just asked you. And he does that consistently. I would be like,
yeah.
And the fact that this is not his first time asking for a mistrial. This is like a every 20 minutes kind of situation.
Yeah, this is just for out 5 days. I don't think they had day 5 yet. This is from like the 4 days, Monday, Tuesday, Wednesday, and Thursday. All this stuff happened. This is happening in a very short amount of time.
Yeah, and this is just a clip.
Yeah.
Like this is a clip of different moments. This
Yeah,
is not the entire.
Yeah, no, it's not the first day or second day. It's just they skip around.
Yeah.
Mr. Bolden, do you care to respond before I make a response?
Your Honor, Mr. Cruz has failed to make the proper foundation for a prior inconsistent statement. He has not asked the witness a question that the witness then denied. And so it's just not a proper foundation. So that's the basis of the state's objection. As to his motion, I don't necessarily think I have to make a response.
All right. Thank you, Mr. Bolden. So, Mr. Cruz, the first thing I want to say, and we are outside the presence of the jury, is that it is unfortunate that your constant comments about the unfairness of this trial it's very unfortunate. It is outside the presence of the jury, but it is not appropriate to continually just argue to the court that things are unfair and that somehow the defense is handcuffed because of the court's rulings. As I stated before, the court endeavors in every respect to make rulings based on law. So that's the first thing. And, having a slight tantrum every time you get a ruling that you don't agree with is really not appropriate. And I'm going to ask you to.
And Jenny, I will, I do have this on 1.25 speed, so it is a little faster. But I will admit that sometimes with some people, even when they're not trying to be, a Southern accent can come across as very condescending. I had a friend, bless her heart, she passed away. But I loved her. She was sweet as hell. However, her Southern accent, combining like backwoods Florida, Miami, Cuban, and rural Georgia and Kentucky, all of that together combined, she sounded very condescending when she talked, even when she wasn't trying to be. So that combined with a faster speed is plus the fact that she is sick of him asking for mistrials and not providing proper paperwork. She sanctioned him in opening statements because he didn't file a motion or the proper motions that she actually told him, hey, you need to file this. And it would be untimely, but I will still consider it. And he still didn't do it. So it's a lot.
consider that moving forward. The second thing is the state is correct, Mr. Cruz, in terms of the procedure to request to admit an inconsistent statement, and you have not done it properly. I will say, for the record, in this particular moment, that your question was not the appropriate question to ask to recognize an inconsistent statement. It was kind of a trick question of sorts. You asked her to describe that particular piece of clothing, and her response was, I would say it was a hoodie, as if there was sort of the question allowed this witness, at least in my impression, to sort of pick, was it sort of a shirt or was it a hoodie? And the testimony, as I heard it, was that she elected to sort of describe it as a hoodie. If you would like to make an argument that in and of itself is what the law says is an inconsistent statement under the evidence code, then I will hear it. But if not, I'm going to sustain the objection and ask you to move on, sir. You may be heard, yes. And then I'll talk about the mistrial in just a moment, but go ahead.
He just sits and like focuses on all the wrong, like he won't move on. He just
if I
will
vote with
constantly
he
just
could win a lot of these objections because the state really had to head up in these past 5 days. If he knew how to argue, he would win a lot because it's really
I think he just picks the wrong battles.
yeah.
I think he just picks the wrong battles. Like he chooses the wrong like things to focus on.
He don't like her, so he's like, I'm gonna call you out on it. I'm gonna call you out every single time.
And Shenny, you can feel free to disagree. Yeah, I know, but like I've had some people that sound condescending, like even when they're not. They're the way the inflection is just sounds real condescending. I know they're not, but you know that's part of why I love you is we don't always agree, and that's fine. Because guess what? That's part of being human. You know? Yeah. He doesn't seem to understand what impeachment is. Word for word is not it. That's true.
I'm honestly surprised this judge hasn't started yelling yet, to be honest.
Well, the thing that I'm like, look at the defendant's body language. And I'm not a huge like proponent of this is lying, this is truth. But there are universal, you can tell when someone's happy. You can tell when someone's sad. You can tell when someone's angry. You can tell when someone's frustrated. Look at his, like, look at where this froze right now. Look at him and his pose. He just looks annoyed. He just has the body language of someone like, can we just get on with this?
He annoyed at his own attorney.
Like, I'm just not sure what to. And does this co-counsel maybe? I'm just not sure what these two individuals think of.
His co-counsel made one argument during, I think he was during the Daubert hearing, or maybe one of the hearings outside the prejudice jury. But only thing you had, Cruz is the only one arguing. His co-counsel don't really do anything as far as like the trial is concerned. I didn't even know he had co-counsel till one got up and started talking. I'm like, oh, he had oh, okay.
I'm just, yeah, I don't know.
If another court has a statute, say I'm a little statute now, that's okay. But if you have it readily available.
Well, I mean, Mr. Cruz, I'm not going to advise you on the law. And I think you need to be here prepared to argue it.
No, I just said if you had a copy of the statute, I was just trying to say on the course of time, but I'll pull it up there.
You guys, I didn't ask you to.
Exactly.
Give me the call. They really don't like each other.
But I will give this defendant credit though, because usually, okay, go on. Usually when a defendant is there, they can do no wrong. Like he's actually showing human emotions.
Yeah.
Not so much
they have anything on the case. I know people won't disagree with me, but I really don't see, maybe there's more. State hadn't arrested yet, but I really don't see nothing that needs to get anything.
It all comes down to that evidence with that expert.
Yeah.
But this defendant, like, you can do no right. You either smile too much and you're cocky, or you don't smile and you're heartless. He's actually showing like normal. To me, he's showing like a normal like range of someone who's sitting there is not uncomfortable, but not comfortable kind of situation. It's more like, what the hell is going on here? He does look frustrated though.
OCGA. The statute is OCGA 24-6-613. Prior statement of witness is the title of that section. Under subsection A, the law provides, in examining a witness concerning a prior statement made by the witness, whether written or not, the statement need not be shown nor its contents disclosed to the witness at the time. Provided, however, upon request, the same shall be shown or disclosed to opposing counsel. Your Honor, in this case, I went above and beyond. I actually chose to refresh her recollection as opposed to impeaching her when we were talking about her statement. She heard the entire statement. I told opposing counsel, this is what I have. They heard the entire statement. Subsection B provides, except as provided in Code Section 24-806, extrinsic evidence of a prior inconsistent statement by a witness shall not be admissible unless, first, the witness is first afforded an opportunity to explain or deny the prior inconsistent statement, which we did. I said, Your Honor, this is a quote. I read the statement as a quote. She said it was a hoodie. I confronted her with the statement, gave her opportunity. She still chose to say this was a hoodie. Second, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement. That's that. The state will have opportunity to examine her on the prior inconsistent statement.
Mr. Cruz, what is the statement you're saying is inconsistent with this witness's testimony?
Sure.
I think that's part of what the state was endeavoring to argue. So what is it?
So the written question that I asked the individual that she saw walking, did she state he was wearing like an orange colored shirt? She said that he was wearing a hoodie.
Well, that wasn't the question you asked, Mr. Cruz. The question you asked gave her an option to sort of describe what she meant. And you said something to the effect of, was it like a hoodie or a shirt? And she opined it was like, I'll say a hoodie. I'm not sure that's an inconsistent statement, but I will let you question this witness again with specific questions if you would like to elicit the proper information for the court. I will let you question her right now out of the presence of the jury, and we can go from there.
Sure. In your prior statement in law enforcement, did you state he was wearing like an orange colored shirt, orange or red, something bright?
Yes.
We can bring the jury back in. That's it.
All right. And Mr. Cruz, I want to comment on your motion for mistrial. I'm going to deny that motion.
Again,
The granting of a mistrial by the court is a very, of course, as you are well aware, extreme option. And it is done in very limited circumstances where the matters that have been presented in court are of such a prejudicial matter, such a prejudicial level that the defendant cannot receive a fair trial. And with regard to your motion, you have not sufficiently shown this court that that exists. And so I'm going to deny your motion. All right. Can you bring the jury in, please? Thank you. Walden, you have an objection?
I do, Your Honor. Mr.
And
Dalrymple and I should talk
just
in
the
anticipation of
contempt thing.
us getting to this point over the week.
This is
what'd you
just
say?
this is just the contempt. This clip is just the contempt.
Oh, this is a clip.
Yeah.
We can, oh, this one. Yeah, we can get rid of that. All right. So this guy, like, it's not even about the defendant at this point. It's about, it's not even about the defendant at this point. It's about the lawyer. And it's just, I don't know, like, it when a trial becomes about how much the judge and the defense attorney are butting heads. Yeah, mistrial to these lawyers is like grounds to Brooks.
He's playing to the media, and he's saying in his opening statement, "We are not here to play to the media. We're here to get justice in this case." I'm like, you're playing to the media when you argue stuff like this for 15 minutes, every 15 minutes throughout the day.
Oh, I have to add you. There we go. Right there. Let's stop that. I have to share this. Chrome tab. So this is the amended motion to disqualify the judge. So this is the problem with downloading
This
or
not authorized
with
stuff.
Yeah, not an authorized copy. So reading it becomes just a tad bit messy for my brain. But it's, but if I were to add this document, it would be about $40, and we're just not, we're not doing that.
That's no chump change.
Oh. All right. Let's see. This is the amended motion. We know this. This motion is timely filed pursuant to Georgia statute, which no one gives a damn about, which provides filing and presentation. I've learned to skip over statute numbers because 1/10 of the chat actually cares what the statute number is, and they can see it and they can read it for themselves. Like, you know what I mean?
Yeah.
They can write it down and read it to, I don't have chat rules. my chat rules are just don't offend. Well, what are my chat rules, Flashman? Don't insult my guest.
Yeah.
But that's not a problem.
Don't insult the Army, Navy.
Yeah, don't insult don't call me Army.
Yeah.
Don't call me Army. Don't insult my guest. And if y'all have problems with each other in chat, leave it out of my chat. There's my someone define chat rules. Because in the hail streams, you'll get people from both sides that come in my chat and they hate each other. There are people in the chat who hate each other. And I just don't oh yeah, and don't make negative comments about my child because my mods bite, but so do I. Oh, and talking trash and truth, I don't know how you operate, but I have a hater of the week segment too. So like when someone leaves me a crappy comment in my comment section, I will screenshot it and share it on my next live stream so that everybody can see it. Because if you're going to be stupid, I'm going to let everybody know. And you want your 15 minutes of fame, I'm going to give it to people. Because I'm that, because I'm that, yeah.
Oh, yeah. Shenny calls me fresh. I don't remember how that got started.
That's, well, Roy, if it'll protect your ego, you can think that.
And the dog is barking.
Oh, and everybody wish Roy a happy birthday. It was his birthday a couple days ago. So, and Diana, how are you? It's 2 degrees with a real feel of -26. I'm staying in bed. Yeah.
Oof.
And Uncle Buck. And my mom is in the chat. Oh yes, and my parents are both mods on my channel. So if you talk about my child, my parents will attack you.
The policy is you're probably going to hear from Mama Squid, Papa Squid. You're going to hear from Squid. Probably going to hear more from Squid.
No, you're probably going to hear from. So Zach, everybody knows Zach. Zach is my personal fat shamer. I like Zach because we have a thing. Like he's my personal fat shamer. He asked me if I went to the gym today, and when my dad didn't know that inside joke, my dad actually went after Zach, and I was like, no, it's good. It's good. It's like it's an inside joke that's been going on for like a year and a half. Like it's good. Like it's like It's an inside joke. It's all good. So yeah, my parents are both mods on my channel and in the chat quite frequently. So just don't piss off the parents. Don't insult me because you will literally have to deal with my parents, and that's not me. That's not a me problem. That's my parents. They're in my chat regularly, so good luck. All right. Okay. This motion is filed. Motion is not later than 10 days before a hearing or the trial. Due to undersigned counsel learning of the alleged grounds for recusal on January 15th, 2026, and our hearing date is scheduled for January 21st.
And trial started February 2nd. Yeah, 2nd.
On January 15th, 2026, the Honorable District Attorney Kalki Yalamanchili.
Yeah.
The Honorable District Attorney Chris Bolden, undersigned counsel, and Mr. Edrick Faust appeared for Honorable Judge Lisa Lott for motions hearing on the 1:30 p.m. calendar. Oh, and that lawyer talks like he's writing a motion.
Yeah, when he argues the motion sometimes you hear say the undersigned counsel requests that under this. I'm like, you are the undersigned counsel. What are you
Like, well, it was funny. He thought Papa Squid was gonna reach through the air and squash Zach, you know. And if anyone talks about your child, they have to do with all of us. And I appreciate that, Diana. Well, Squiddy, no hair grows on my tongue. I need to feel the chat before I unleash my full personality. You can unleash your personality here. It's welcome here. If Bobby can unleash his personality here, you can unleash yours. Just kidding, Bobby. I love you. During the January 15th proceedings, the court instructed Mr. Faust through counsel that he was not to file any legal briefs following rulings by the trial court. Undersigned counsel cannot follow said directive, as same would violate Professional Rule of Conduct 1.3, which provides a lawyer shall act with reasonable diligence and promptness in representing a client. Reasonable diligence, as used in this rule, means that a lawyer shall not. And I had a conversation with somebody this morning about shall versus may. We were discussing something in a different case, and I was like, I thought the statute that we were referring to used may, and it was like, I hate when statutes use may because it leaves it up for interpretation. They may not, they may not. Whereas shall, a little more you have to.
Yeah.
Shall not, without just cause to the detriment of the client, in effect, willfully abandon or willfully disregard a legal matter entrusted to the lawyer. Comment 1 explains a lawyer should pursue a matter on behalf of a client despite opposition, obstruction, or personal inconvenience to the lawyer, and may take whatever lawful ethical measures are required to vindicate a client's cause or endeavor. A lawyer should act with commitment and dedication to the interests of the client, with zeal and advocacy upon the client's behalf. Oh, where's Bruce when you need this? Good morning, Heather.
I keep forgetting there's more people with your name in chat. I'm like, wait, you talking to yourself?
I'm like, is this something he reads to himself in the morning when he stands in front of the mirror? Is this like a positive affirmation? I mean, if you're going to read a positive affirmation as a lawyer, this should be it. I'm just saying. Just saying. The court's instruction to Mr. Faust's counsel was constitutionally unlawful, unethical, and improper, and if followed, would obstruct Mr. Faust's building of the appellate record and deprive Mr. Faust of his constitutional right to effective assistance of counsel. Okay. Additionally, January 15th, the court refused to reconsider its order denying Mr. Faust's amended motion to suppress evidence obtained due to illegal searches and seizures, hereafter motion to suppress evidence, despite the state conceding that the law was unfavorable to the state's position during a prior hearing. In regards to the motion, on November 13th, the following exchange occurred in regard to said motion. Mr. Bolden, with what I'm trying to explain, there's a motion to suppress that Mr. Cruz filed on October 2nd. Okay. Mr. Bolden, the second part of the motion to suppress is they used that cell phone information to have a Georgia state trooper, well, you never mess with GSP, pull Mr. Faust over for the purpose of obtaining surreptitious DNA sample. But it's the and I don't know. Bye, Shenny.
See ya.
See ya. See, and the thing about being pulled over is like, how do they know? Well, how do they know it's you? You know what I mean? Like, it could be your car, but that doesn't mean it's you. So it's, I just have issues with, I have questions. Things just don't. Mm. The state is going to concede that controlling case law on the stop by the trooper is adverse to the state's position. The controlling case law, not the law. There's a difference between the case law and the law. Like, from the trooper's perspective and what is lawful, a lawful stop, and the case law about allowing that lawful stop and evidence obtained in that lawful stop in court. No. You know? And literally, the court's just saying, okay, so the part of the motion to suppress we're not contesting. We're conceding that anything related to the Trooper Wooten's traffic stop should be excluded. Mr. Cruz, will a written order granting the motion to suppress come out, or how would the Honorable Court deal with that now that how would we respond to the motion during the status? Let me look at the motion first before I answer that question, but of course, anything that the state concedes or stipulates to, or vice versa, will certainly put in writing, but I need to take a look at what the motion says. That, I don't understand why why he put this in this motion.
There's nothing wrong with that. I mean, they do that all the time. Look at
Yeah.
an advisement. Look at it. They not at
Well,
trial yet.
And the court literally said, but of course, anything that the state either concedes or stipulates to, or vice versa, will certainly put in writing. But I need to take a look at what the motion says. Obviously, she's not going to agree to anything until she reads the motion.
Yep.
And that transcript is in the docket too. Everything's in the docket.
He hung up on the wrong thing.
The court this is where one of the reasons that I personally like to look at documents before a trial, so that when things come up in a trial or there's issues in a trial, like the judge and the prosecutor don't get along, or the judge and the defense attorney don't get along, I have a background as to why. Because I don't like question. Like, I don't like going, huh? This is weird. Huh? I have a hard time just watching a trial. I know some people do great with that, but I have a hard time watching a trial and not knowing the background.
I love seeing the pre-trial stuff. I know lawyers on YouTube, defense diaries, they say that the way that most of the fighting is done is in pre-trial litigation, because it determines what the trial is going to look like.
That is true. And it's also from a layperson's in a non-jury perspective, to see what is the jury gets to see versus what the jury doesn't get to see.
Yeah.
And what we know as court watchers versus what the jury is actually hearing, and how that shapes the narrative. It makes you look at the whole world differently, or me anyway. Like, it's one of the reasons that I got interested in, like, from the politics side of things, looking at articles and trying to find the rest of the story, and then telling everybody the rest of the story, is because of court cases. And when I knew that only part of the information was given to me as a jury member, I wanted to know the rest of the story. So when I read an article about somebody said something, I want to know what they're leaving out.
Yeah.
And that's
I really wish the pre-trial hearings were televised in the case. We only had one bond hearing from when he was first arrested and when he pled not guilty. So
it's just Such a blatant disregard of the law in favor of injustice was terrifying for Mr. Faust, as undersigned counsel had expressed it was a mistake. However, the court's actions made it clear that it does not care about the fairness of Mr. Faust's trial, nor whether he's innocent, but solely obtaining a conviction.
That's not what she said.
That's not what she said.
I'm trying to make it sense of what he said. Yeah, I don't know. I don't know how you made that inference.
Like, maybe my interpretation of English is wrong, and I could be completely wrong, but it's not my interpretation of what.
I'll look at it and have something for you later on. I don't know what he saying that's so wrong. I don't really get it. It's like he just started practicing law last week or a week before they argued this.
Well, I kind of want to do a little research on him and how much. No, I'm reading. I am reading. I'm just not participating. Don't read the chat. Don't read the chat. Don't read the chat. This court's actions supports the court's disqualifying itself pursuant to Rule 2.11 of the Code of Judicial Conduct, which provides that judges shall disqualify themselves in any proceedings in which their impartiality might reasonably be questioned. An impartial judge does not deny a substantive defense motion regarding the admissibility of evidence when the state concedes that based on the law it cannot meet its burden. In light of, and this is 28 pages long.
Dang.
Yeah.
Golly.
Yeah. And we're going to get to, so y'all know me, I take notes. So we're going to get to, because if I don't remember. And that's part of why trial watching during the day, I can't just do like a recap video during the night because I won't remember.
And it would be hard for you to stream this case because many times I have emotion outside the presence of the jury. It's hard. That's why I say I hope I get facts right because it's hard to you lose focus because he arguing most of the time outside the presence of the jury. And when it comes back like
you are
this testimony?
T3, you are fine. You are fine. I just get derailed to the point where I have derailed merch. So
forget about that.
I have no problem from a topic perspective. It's just getting me to stay on topic when I see things in the chat that I want to laugh at and point out. I have derailed merch for a reason, and this topic of conversation in the chat right now is one of the reasons. Yeah, see? Good job at avoiding derailment. See? Right there. See? Oh my God.
Oh, I mean, we used to get squid derailed so much 2 years ago when I first.
Oh my God. Oh, I'm so much better now. No, I'm not. No, I'm not. No, I'm not. And I am working on new merch. I just can't figure out a design that I like. I just can't. But there's stay in your lane. There's rage quitter. Because Freckled Ginger is my resident rage quitter. But there's stay in your lane, there's rage quitter, and then there's one more.
We need a Pettyverse shirt.
Yes. Yeah. There's that too. Wait, an AT2 Hummer tag derailed? Say it ain't so. Yeah. One with brain damage. Significant brain damage. Like this, I feel like all these motions that I read give me brain damage. Like, and his footnote is just the Georgia Code of Judicial Conduct's terminology of impartial, which I don't think is fair to read and bore you.
No.
Like, refresh page. No, I don't want to. Okay.
I tried reading.
I've been on this page for so long that it decided to refresh.
I tried reading the motion to what motion was it to Eva? I think for clarification in the Tyler Robinson case. I'm like, why is this motion so doggone long? I can't do it.
There is some motions where I'm like, does this literally need to be this long? We're in the Hannah or the Sarah Grace Patrick trial,
Mm.
her case, those motions are like 5 pages, 6
Yeah.
pages. Be it there is not a lot that's filed.
Yeah.
Most of them are orders from the judge for cameras.
Yeah.
Nobody is saying a word in that trial or in that case. But at the same time, it's like we're not getting any information. But what the orders that do come out and the motions that are filed are super easy to read because they're like 6 pages.
Yeah, it's what was it? 140 case. I think it's like the Microsoft executive case, Shannon Gardner and stuff like that. I need to see what's going on with that case. The motion they filed to disqualify the state attorneys are like 63 pages. I'm like, what?
So Gail says we need a shirt with Squid wearing her boxer shorts. So if y'all have, did you see that, Flash?
No.
So we will just take a quick trip down the derailment section of YouTube. We will go to, and I know this person is not everybody's favorite person, and that's totally fine. It's totally fine. But so hold on. And he shared this with me. So the full video is out to members only on his channel, but the full video will be out on the 9th. However, we have to hold on. I gotta back this up. So we are going to share this. Let's go to the media presentation. We're going to share this. So this was made by DJ Radis.
Okay, yeah. I remember him.
The fighters are in the ring, and they are ready. So for the thousands in attendance and the millions watching from around the world, ladies and gentlemen, stand up and show some respect. Tonight, it's a one-fall hardcore showdown. No countouts, no easy escapes, no shortcuts. Anything in the ring is legal, and only the toughest shall survive. Fighting out of the red corner, she makes inside. Brings aircraft carrier level impact.
Just wait,
a disciplined warrior with precision in her strikes and steel in her spirit. A former U.S. Aviation Electronics Technician, second class, air warfare qualified, served with honor from 2004 to 2009. She kept the systems running that kept the skies safe, and now she's grounded just long enough to dominate a different battlefield. By day, a full-time mom with unstoppable heart. By night, a sharp-minded legal case study reporter breaking down facts like opponents.
He gives me too much
calculated,
credit.
combat ready. She doesn't need to be the because she's the one you never see coming. So make some noise for Squid Pro Quo. And next is Squid Pro Quo's opponent. You don't have to cheer. In fact, we expect the opposite. Fighting out of the blue corner. He's the self-proclaimed legal mastermind of technicalities. The man who treats courtrooms like cardio, always running somewhere. Known far and wide as the ambulance-chasing attorney, a specialist in loopholes, lying, and suddenly not being available for comment. He ducks, he dodges, he objects, and somehow always claims it was taken out of context. Calling himself a ladies' man, rocking a dazzling blue leotard and matching tutu like it's Fashion Week at the courthouse. Flashy? Yes. Subtle? Never. Dignity? Currently under legal review in all 50 states. And that larger-than-life nose. Legend says it's not just for breathing. That's where he keeps all his legal arguments. And he always has his fingers up in it, digging for another one. You may not cheer him. You may not trust him. But you will hear about him. Make whatever noise you feel is appropriate. Bruce the Deuce.
Oh, man.
I mean, but he has it started off because Stupid Dave, aka Milltown's Worst, aka the cheesehead or the dumb cheesehead, said in a live stream chat that he was getting in shape and wanted to fight DJ Radis or Vag Nation.
Oh,
That was the quote. That was the exact quote.
Turn it into a Jake Paul situation.
It turned into Radis making himself versus So this is the this here. I'll share this, but I will show you the um I will show you the this is the just saying I'm getting fit and I'd love to be on the undercard. LOL. Book it. Radis or Vag would be fair, I think. And so he made a DJ Radis versus Stupid Dave boxing match. And then it turned into somebody made a joke that I could see you versus Fleesa, and I was like, no, I want Bruce. Because Bruce went after my kid. So I want Bruce. And I was like, I'll take Bruce. And then it turned into that. And then it was he has made tag team champions Megan and Tug versus Lips and Doritos, which is Leslie Lips and her husband. He has made the fight announcement and the full. He has made tag team tables, ladders, and chairs match, Jeremy and George versus Liar, Net, and Crook. He has the fight announcement and the full. Like and then Squid versus Deuce. And the full one is out for his members only. The fight announcement was out for everybody, but the full one is out for members only, and it'll be released for everybody on the 9th, which is Monday.
Oh, cool.
So it's
watch.
it's just it becomes a
Oh man.
Yep. Yeah. However, it's kind of a joke, but it kind of not exactly funny, because this was me in 2014. Let's see if I can find my. Let's see if I can find it. I have to. So this was me in 2014. Recognize the tattoo?
Oh wow.
So
Yeah, that wouldn't have went well for him. I went in the ring.
I'm not. Yeah, that's me in 2014. Rest in peace, Duke Rufus. Yep. So there's my me right there when I was skinnier. Like I can see collarbones in that picture. I was also 12 years younger. I'm like, look at that. Look at that picture. Look at that. It's baby squid. Look how skinny my arms are. Like, look how tiny my arms are.
Probably dropping people left and right.
Oh. Yeah. That was the Yep. Take care of your skin now. I started using tallow. So I started using beef tallow. So it's definitely a thing. It's definitely a thing. I can't believe I started using beef tallow. It's made in Canada, the company I'm using, and so far I really like it. Like you have itty bitty feet. Yes, I wear a size 6.5.
Y'all people would be like, "Wow, you got some big feet." I told y'all about what I wear a size 13.
Yeah, I wear a size 6.5. Even to my friends, I went to the gym the other day to drop something off to my friend, and she's like, "You're not going to work out?" No, I don't have shoes. I was wearing UGG boots, and she's like, "I have an extra pair of shoes," and she's like, "Well, wait, you have baby feet?" And I was like, "Yeah." She's like, "I wear a size 9." I was like, "I have a 6.5." Like, I have baby feet. Like, be nice. Be nice. I have baby feet. Like, See, this is why short people scare me. Oh my goodness. This is November 13th. I'm skipping around because we're not reading through 28 pages.
That's a 5 page.
Court held a hearing for admission of other smexy time acts.
Oh,
This hearing was for the purpose of the state to obtain permission to admit Miss Brenda Swinney's allegation that Mr. Faust was smexily not good with her on multiple occasions.
I'm guessing that's where that shield stuff coming.
Undersigned counsel had spoken with Miss Swinney, and she admitted that she does not recall a single incident of Mr. Faust being not nice with her. Mr. Faust lawfully served Brenda Swinney with a subpoena to appear at that hearing. At the start of the hearing, Miss Swinney was nowhere to be found. Undersigned counsel explained to the court that Miss Swinney had been subpoenaed, and Miss Swinney's testimony would be that, to her recollection, there was never any smexy time naughty stuff. God, YouTube, why can't you just let me read it?
I think
It would be.
I think that the person he tried on yesterday, he tried to add somebody to the witness list. He said he couldn't locate the witness, and he was like, I want to amend the witness list tonight. I'm giving the state notice, and the state like, well, all right, we object, and the court was like, no, I'm not going to allow that. So I think that might be who we're talking about.
Squid starred in Willy Wonka's Oompa Loompa number 3. No, that's me now. The court denied the request, depriving Mr. Faust of the compulsory process in favor of admitting the state's evidence at the expense of Mr. Faust's rights. I might kind of agree with him on that one, but one ruling that goes against you, one ruling that goes against you is not reason to recuse the judge.
Yeah.
The other one that we mentioned, I'm not. No.
Yeah, they lose. I mean, people lose all the time. You just roll with the punches, like, all right, I messed up, or take it up on appeal.
During the November 13th hearing, court told Mr. Faust's counsel that lawfully made speaking objection was not a thing. Exchange, speaking objection, Your Honor. Objection, speaking objection. What? Huh? Okay. Your objection while speaking is a speaking objection.
No. What he mean by speaking objection is, like, they got argument.
You're right.
About objection, Your Honor. The counsel has said that this is this and this is this, and counsel shouldn't do this. That's what he mean by speaking objection.
So I think she's interpreting it as what I said.
Okay. Maybe. I mean, I don't know. That's why I wish some of these preachers out here were talking about it.
No, but I think she's I think he's speaking objection as like an argument, and she's like, your objection, well, you just objected as a speaking objection. Yeah. So, yeah. Yep, my mom shops in the kids department for clothes, both size and height. So, hey, Paul. All right, speaking objection. I'm objecting to a speaking objection. Tell me what you mean. Sure. So, speaking objection. A proper objection is an objection. Relevance, objection, hearsay, lack of foundation. This is a speaking objection. It's an objection where you're making an argument. I object to a speaking objection. Okay, Mr. Cruz, I'm just going to tell you right now that's not a thing. I'm going to overrule that objection.
Yeah, okay, so yeah, what he's saying, that's not a speaking objection. He was saying objection and relevance. That's not a speaking objection. That's just an objection. I don't even have to be a lawyer to know that.
Well, he said a proper objection is objection relevance.
Oh, okay.
And then he said, this is the speaking objection. This is an objection where you're making an argument. I object to a speaking objection.
I mean, it's a thing, but I mean, there's no jury practice, so you don't have to worry about just saying objection relevance. So I don't really get why they do that.
Well, I think it's state by state.
Oh, okay. Yeah, because I forgot in Massachusetts, you can't really say, some courts in Massachusetts, you can't even say objection argument. You just have to say objection, like in Karen Reed. They just had to say objection. And she ruled. I'm like, how do you know what to rule on? You don't know the grounds for it.
So, I think speaking objections are more for a trial than a hearing. So, I don't know. That's one of the things where me not being a lawyer is in full. But apparently, this judge doesn't know what he was talking about either. So I'm wondering if it's a state, because I have heard.
Yeah, because usually in front of a jury, they like just say objection, argumentative. You have argument, come to the bench or something or the other. Instead of saying objection, Your Honor, this statute said the counsel can't do this and this. I'm like, that's how I always heard it described. I'm like, I don't know. Actually, I'm not a lawyer, so I don't know either.
So according to legal clarity, a speaking objection extends beyond the simple statement of its legal basis, such as objection hearsay or objection relevance, by including additional commentary or argumentation. This type of objection is discouraged, and it can disrupt the trial and prejudice the jury by introducing arguments that should be reserved for other stages of trial.
Like
in
if
some
I would say like objection hearsay, Squid Pro Quo said Bruce is an idiot, and this is why she said he's an idiot. That's the speaking objection.
Well, what I'm thinking is maybe she said that's not a thing.
Yeah.
She might have misspoke and said that's not a thing here.
Yeah. Or he could, or
Like,
Cruz could be taking stuff out of context because apparently he does.
Sure. That's true too. He does have the hearing transcript, page 42. The transcripts are in the docket. So later on, we can do this again next weekend if you want to, for week 2. And I can fix, or not fix, but I can fact check.
Yeah.
So if you want to do this the same time next weekend, we can too.
Sure.
However, it says in some jurisdictions, speaking objections are explicitly prohibited. Judges have the authority to admonish attorneys who engage in them, particularly in jury trials.
Yep.
So attorneys are expected to reserve arguments for designated stages, such as motions in limine or closing arguments. So maybe the judge, this is just me, if he quoted her correctly.
Yeah.
This is just me playing devil's advocate. Maybe she said that's not a thing. Maybe she meant that's not a thing in my courtroom.
Yeah.
And he should know that based on the jurisdiction of.
If she said that he did, that's on him. She interpreted that way, and she did say that way. If I'm in his shoes, she said that's not a gesture. I'm like, well, Your Honor, do you mean? I just asked you for some clarification. Do you mean here or in general? In my follow up. I'm like, I would be like, for purposes of this hearing or just in general, because in general,
he keeps going on about objections that he didn't win. So,
that's
court denied Faust the opportunity to offer proffer, excluded cross-examination questions on the record, as it is required for appellate review, then authorized by a Georgia statute.
I didn't think that's how that worked. I thought you, like I said, I thought you had to you didn't give up your hand and what you're going to ask on cross-examination. I don't know.
No, he seems to have exception to the November 13th hearing is a lot. So it's the court's pattern of conduct is also extended to communications between Mr. Faust's counsel and the Honorable Court. October 2nd, undersigned counsel sent Honorable Court motion and proposed order for the court's consideration before Mr. Faust's filing deadline. Court did not respond to counsel, Exhibit B. October 16th, undersigned counsel sent the court an email. You sent ex parte communications advising that a ruling was needed on a pending motion before November 3rd. The court did not respond to Faust counsel.
Yeah, I always thought ex parte was like sensitive issues, not about motion. I always thought like if he had like some type of medical issue or something, and they like, well, we want to talk to the court ex parte.
Well, here's the thing. Then this is where he just needs to stop, in my opinion. If the judge is truly effing up, just let her F up, because that's your appellate.
And that's how you
That's your appeal.
that's how you get your client's case overturned.
Because the appellate issues are not matters of guilt or innocence or the law. It's a matter of whether the laws were followed.
Yeah.
The procedures were followed. It's more procedural than anything else. Hold on one second. Bear with me. I got to go mama duties.
Mm-hmm. So, ladies and gentlemen, what do you think of the case so far? What do you think of Cruz and his conduct and stuff like that? Do y'all think he has some points, or is it just he's just trying to stall and delay? I honestly think this guy is irritating.
Thanks. Mr. Squid's asleep on the couch. He went to work this morning, so he's worked 6 days this week. So he's sleeping on the couch, and she was yelling for him because he usually helps her when I'm on the computer, and she didn't want my help. And we're in that phase where it's like she'll walk right past me and ask for him.
Yeah.
Or I'll be standing there and she'll ask for him, or he'll be standing there and she'll ask for me. And it's like, we're right here.
When we're that age, when kids that age, because I know, I was a little older than her when I was 7. My mom would come home, and my grandmother, she would watch me during the day, and I'd be upstairs with my grandma. She's like, "Your mama home, go downstairs." And I always want to be around her. So it's just favorites and stuff like that. That goes sometimes.
Yeah, and you can tell he didn't mean to fall asleep because his laptop's in his lap.
It'd be like that sometimes.
Oh yeah, it'd be like that.
I fell asleep watching Hulu last night.
He wakes up at 2:45 and leaves before 3 a.m. So
yeah. Definitely the Cruz is something else.
Yeah. She wants to go back on the potty, but she just got off of the potty, and it's like, you just went. Like, you don't need to sit there 24/7. We like it, but we like it a little too much. We don't need to sit there all day. So she's currently going to be sitting down, and will need my help in a minute, because she can do the undo, but she can't the do. Like, is she a cat?
Cat.
Oh boy. All right. October 24th, the state sent court an email regarding a joint continuous hearing within 24 hours. And even on a Saturday, the court responded to the state. Well, okay. How do you know that the court sent an email on a Saturday?
And
Were you CC'd on the email?
Because I'm like, how do you? Yeah, I guess in that case you did send to all.
Oops. Where are we at? 9. This is the problem with doing this. Is we
Lose, please.
This is the problem with the site. But if I were to see if there's a little Kurt here, and I'm just not nope.
You don't want to act any bad nothing.
I ain't got that kind of money.
You just purchased a document. Like, what?
What? Huh? No. Court's pattern of conduct has also extended to addressing motions from Faust and the state, in addition to the emails outlined above that went unanswered when a ruling was requested December 11th. Undersigned counsel filed this motion for reconsideration December 30th. Undersigned counsel filed 5 motions for certificates of materiality for witnesses, which is unaddressed until undersigned counsel filed a motion to continue the trial date due to the court's non-responsive to said motions. Well, in Georgia, and this is one thing about following court cases all over the country is different states have different amounts of time.
Yeah.
And also, it's one of those situations where just because she might be taking all the time that she wants to, because this is probably not her only case.
Yeah.
And
she's the chief judge in that area. So she's the top judge. She's gonna have a lot of responsibility.
However, the state filed a petition for writ of habeas corpus ad testificandum, God, freaking Latin, January 12th, and in a matter of hours, the court entered an order to secure the state's witness January 12th. The court delayed almost 2 weeks in scheduling a date for Mr. Faust to secure his witness, but immediately issued an order to ensure that the state secured witnesses at trial. That's what I don't understand, though. That I do.
Yeah.
I don't necessarily, it's not a reason for recusal.
Yeah, there's some questionable stuff that she did. Like some in the rule, I'm like, it's a bit of a stretch. But I'm like, does it deserve to be overturned on appeal, or does she deserve to be kicked out the case? Not really. I mean, it's kind of like, I probably wouldn't, but like I said, I'm not an attorney, so okay.
And here's the thing about it, though. If this is all the stuff she's doing, it might not be not illegal. That's not the word for it, but out of her scope in the sense of she might have 30 days and she might wait till day 28.
Yeah, just like for instance, on that case in Ohio on filing, that Darnell Jones case, the court would file like a deadline, like, all right, you have this till like January 17th to file this motion. Their motion will come in like January 16th or something or the other, or they'll ask to extend it. But you can come like either the day of or the day before.
Well, and she might be responding to the state right away. And also, how long are the state's this is one other thing I'm going to look at. How long are the state's motions versus his?
Yeah.
And how, because if the state's motions and they're asking for things that are like 3 pages long, they're easy to read.
Yeah. As opposed
versus,
to like 20 or 30 pages where you got to actually look at case law, like, all right, let me read this carefully, read it a couple of times.
Yeah, where you're having to, like, there's more to it. This is where, okay, for me anyway, when I look at things and when I judge people or situations, nuance matters. So on the surface, they're responding to the state really quick and they're waiting to respond to me right before the deadline.
Yeah.
That's shitty. But what am I doing that might be causing the judge to not want to respond to me right away?
That's why I was starting to my stuff like, let me make sure this not a big problem to see if I'm writing either something wrong or I'm just writing it too long.
Nick Starro Raiders.
Oh, cool.
Hey, Nick. How is everybody doing? So that's one of the issues that I'm seeing is like, what is he doing that is there, I'm not saying the judge is right. I'm just saying, is there a reason?
Yeah.
I'm going to look at it because based on this is a lot of like, I mean, this is long. And if this is just, remember, there's hundreds of documents.
Yeah.
Hundreds.
Yeah, I've only seen his earlier documents that he found when the case first broke. And I forgot about this case because they ain't public. They ain't have anything in the media until day one. I'm like, oh, I forgot about this case. But this motions used to be shorter, but they could have got long because the motions before used to be like extensions of time for discovery, bar motions. Those aren't going to be that long. But motions like this, I'm like, wow, this is a long motion.
Yeah, and long motions are a thing, but if if the state is filing motions that are 10 pages,
Yeah.
6 to 10 pages that are easy to read or short or one motion or one issue, one motion kind of situations, and not like this.
Be like
Because this to me is
the state
whiny.
want to admit this witness to the witness list. This statute said this. Wherefore, we ask the court to grant our motion. That's easy as opposed to, well, we want this, and this statute said this. Now, section 3, procedural history, and then section 4 would be like, I don't know, witnesses background. Like, you don't need all that.
That's yes, and Flash fan, that's one of the reasons that I love the way you think, because you have I am y'all, for anybody just joining who hasn't been on my channel before and is lurking, I had brain surgery. So sometimes I know what I want to say, but I can't get my mouth to actually come up with the words. And that's where my friends and sometimes the chat can help me out, because sometimes it just doesn't come out like I want it to. It just for lack of not for lack of trying. Like however, it's just maybe the state's motions are easier to read and don't have unintended. And I am not a lawyer. I'm not a lawyer by any means. I am just someone who likes reading legal documents, because legal documents, generally speaking, don't change, where emotions and people's opinions and things can change minute to minute. Documents don't really change. And because I have poor memory, I can always refer back to a document that doesn't change.
Yeah.
So there's that. So this is his Exhibit A. It's verification and written oath in support of motion to disqualify. Denial of hearing on motion. See, this could have been his entire motion
Yeah.
for dismissal or for recusal.
Yeah.
Daubert motion regarding microscopic hair analysis. Like, this could have been his entire motion, and I think that would have been, because he just repeats what he literally repeats.
Yeah.
What he
And you see that in here arguing in court too. So like, it's not just him writing the issue. This is how he talks and how that's his style.
I made a comment when you were streaming it the other day. I made a comment that he talks like he's writing a motion.
Oh yeah, yep. He used all the. I'm surprised he didn't throw a comes now, Edrick Faust in there.
Exhibit. So this was his email to the.
That's
Okay.
another thing. Maybe she didn't respond to, because I thought you're not supposed to communicate with the judge directly. I thought you're supposed to email their quirks and stuff like that.
I've only communicated with a judge directly twice, and I never actually got a response from the judges both times, because that was not the purpose. One time was when Bruce decided to CC me on that freaking email.
Oh God.
He CC'd me on that damn settlement agreement. And I heard Shizzy say that in Georgia, if you're made privy to a confidential settlement agreement, you can be made a party to a case. And like hell was I being a party to any of that shit show.
Yeah.
So I found Judge Belaytho's email, and I forwarded it to Judge Belaytho, and I just said, I just want you to be aware of this. I was CC'd this email. I do not want to be a party to this case. Have a nice day. Peace out. Like, I didn't really say peace out. I had some decorum,
Yeah.
But
yeah, but that probably didn't need a response. And like some of the other emails would be like, you'd be like, I don't want to be a party, and I might be subpoenaed. So what do I need to do? You just make him aware, and you do whatever he wishes.
yes, I literally said I was CC'd on this email. I live in Georgia, and I was I was informed that I could possibly be made a party to this case if involved in settlement talks, and I don't want to be a part of it. So here you go. All right, so that was 116. So this was all like all these transcripts of these hearings are all, well, they are not, some of them are up and some of them aren't. So letter requesting written orders for motion. I'm just like motion for reconsideration of the Honorable Court's November 13th denying all of Mr. Faust's motions to suppress. Like, he just has filed so much.
That sometime this week too, orally. And they got
Oh. So, okay, the writ of habeas corpus is, there's no image of it, but petition for habeas corpus. I'm trying to find something that might be written to I'm trying to find something written by the state that I want to see where I want to see what the state
motions are written out.
yeah, but that's another one written by, see, it's 14 pages. This is from motion for issuance of certificate of materiality for out-of-state witnesses, Laboratory Corporation of America's attendance at trial or production of business record. Do you think there was a better way to write this?
Yeah, that's a long title.
It is just my personal opinion, not a lawyer, just a layperson, that if you're going to write a motion, that the title of the motion, you might want to make it easier for the judge to know what the hell you're talking about.
Especially
before
if I
she
would want to write it short, a short title, because I can't spell. I'm not the greatest speller. I ain't trying to write out long, drawn out stuff, because I don't, like, if I mess up, I don't know how to, I'm not how to spell.
I'm just, well, because of the fact that he repeats the title in his first paragraph.
Yeah.
And I was like, we're not writing an English paper here. We're writing a legal paper. This is me just being picky, and I know people have problems with me being picky because I'm not a lawyer, but like, medical writing, like, I have a background in occupational therapy. I worked in a hospital. I did client and patient notes for 6 years. I write things down. Y'all, you can see the amount of notebooks I have on my freaking shelves. Like, I literally sit with notebooks in hand all the time. That's why you see me waver on my pens, because I sit with a notebook in my hand, because if I don't write shit down, I don't remember. I literally have here, we have we have the planner. We have the iPad and the Apple Pencil. That's what Bruce said my daughter was going to choke on. Bruce has the gag reflex of a porn star. Like, just saying.
You probably would make a good lawyer. All the notes you take, you'd be prepared for cross-examinations.
Well, I did want to be a lawyer when I was little, because I liked to argue, and people kept telling me you like to argue. You like to argue and you like to find loopholes, because my favorite words were why and technically. I'm pretty sure both of my parents regret teaching me the word technically. Because I was the kid who found the loopholes in shit. Because
well, technically speaking, you didn't say I couldn't go outside at all. You just said not right now.
No, that was totally me. That was totally me. That was totally me. Like, one of the offices I go in on Monday nights, I work, or one of the offices I have to work in has a sign that says I'd have a spreadsheet for that, and I'm like, it's not exactly me, but I'm like, I need a notebook for that. Look, like a porn star would mean no good. Yeah, that's true. Well, this is Bruce we're talking about, so you never know. Like,
and now apparently Cruz right the same way.
Hey, Tree Natty Fish. Yeah, I have it on. I get some I have it on subscribers only for 10 minutes, I think, because I get some I'm covering a case sort of like Laura Owens, but I'm covering that other case that's very dramatic and has a lot of haters. So to keep the trolls out. But how are you? I think you picked up that word in the military. No, I picked up that word with mom. Like, yes, according to my father, I will argue if the sun will rise in the morning and in the east. That's pretty much it. Like,
I could imagine.
right.
I could imagine you representing Faust. Or Faust, how do you pronounce it?
And see, based on what I've seen from watching the trial and bits and pieces of it, I just don't like his lawyer. Like, I feel like if he had a different lawyer, things would be like, I have absolutely no idea of guilt or innocence right now.
At this point in time, 5 days in, I'm like, this guy not guilty. They gonna have to really prove it. But I'm like, Cruz is annoying, so I feel like they found him guilty. It's gonna be because his attorney is screwing him over.
Okay, so the judge has orders state consented to motion. So I'm going to see what these are. And these are guys that came from Nick. These are the documents for I know that Nick was just doing the day 5 of or day 4, whatever day it was. I'm so confused. Of the Edrick Faust case. These are the documents in the case. So we have been going over some of them. This is another one of those like motion for issuance. This was his comes now defendant Edrick Faust. Oh, come on. State counsel, Judge Lisa. So she order state consented to motion. So this is what's weird about this judge. She never understood the phrase because I said so. So now both of my parents are in the chat, and there's one and there's the other. So if y'all wonder how I ended up the way I did, blame them. Love you guys.
I used to ask my mom all the time. I used to be like, how come I can't see that? Because I think. I'm like, all right.
So this is supposed to be an order from the judge. She literally just put the first page of his motion.
Oh.
Yeah, this is the title of this up here at the top says state consented to motion. Order state consented to motion. So motion for issuance of certificate of Sean Weiss of Laboratory Corporation of America's attendance at trial. Jesus, the way he writes my.
She probably. I'm not writing all that. I'm just gonna copy and paste this title.
And this judge, man, I was just not really sure. Like, I'm just not really sure what I think because
I guess maybe both of them don't know what we're talking about. Maybe both of them are like messed up people.
So these are some of her orders. Yeah, like literally. Okay, this is another one of her orders. This is order granting. I
mean, my mom used to say 2-star. She said 2-star quality don't mix, and two people who are the same don't mix. So maybe they too similar to each other. Maybe that's why they butt heads. I don't know.
But criminal proceeding order on motion unlimited to exclude testimony of Cedric Jeffries, granted in part and denied in part. So she literally hand wrote. I'm so like. I'll take credit for half. She always challenged me whenever I said anything, and she still does to this day. Yes, and I am 40, and I still challenge my mother.
Wait till baby squid get that age.
Judge is biased. Cruz is not good at arguing his motions. Yeah. Like okay, I'm not sure if I agree with the biased part, but there's definitely something off.
I'm gonna say I won't say biased. I think both of them are too similar, and they can't understand each other.
But I do agree that Judge Cruz is not good at arguing his motions.
Oh no! That's why I say he
No,
would want to lie.
no.
Under any other judge, he probably would want a lot of this stuff if he knew what he. For instance, she granted the motion for the when they wanted to get his mugshot before the jury, and Cruz rightfully objected, said that's a prior crime that shouldn't be admitted. He didn't know how to argue. She said, "Okay, I'm granting your motion not because of your argument, but because I do agree that that shouldn't be flashed before the jury. But what I allow them to do is show it just to show a picture." So I'm like, "Dang, that's bad." When the judge say, "I don't understand you. I'm not granting it because of your argument. I'm granting it because I agree with the gist of what you're saying." Like,
And Tree 90, what do you like being called for short? Just so I don't have to repeat that whole name every time, because I'm bound to screw it up. And I don't want to insult you like that. Think this judge took the motion to recuse personally.
I can see it, I guess.
Yeah.
Because some of
Yeah.
the things she say, she's like, "Well, Mr. Cruz, this is really unfortunate, and this is frustrating to the court. Your comments,
Tree fish.
the
Tree
court
fish.
unbiased." Tree fish.
Jeez, Bobby. So I can see that, because I mean, okay, y'all know me. I call it like I see it. I am all for a woman being in any position anywhere. However, we do have to accept some facts of life. Women, by far, are more emotional than men, even if we try to deny it. So even when we say we're not, like I joke, you have to have emotions in order to hurt my feelings. You have to have feelings in order to hurt them, you know. But at the same time, in general, you cannot deny the biological fact that women's hormones are different than men, and we get a little bit more emotional. Y'all can't deny it. So maybe that's a possibility.
Yeah, I can see
Bobby,
that.
Bobby, shut up.
I can see how people form that opinion that because she does the stuff she does say, like that's unfortunate, and I'm sorry that you had to feel that way. I'm like,
How dare you? My fifis are crying. Yeah, at least we're not like Laura Owens that like files a lawsuit every time we get our feelings hurt. You heard, Flash fan, you heard she's suing Hey Rob now?
Oh no.
Yeah. For harassment, because he's been talking about her lawsuits on his channel.
Sound like that lady a couple months ago hitting true crime.
I just can't. I just can't. But also, like, not one to judge the judge. Actually, I am, because the judge is a person of the state, and the more trials we watch, the more of an anarchist I become. If you're gonna write a handwritten motion, at least make your make your handwriting legible. Don't write like a doctor. Okay, so this is what I wanted to show you guys. This is everything. So we're gonna minimize this. This is Faust's criminal record.
He had a large rap sheet. I just don't know this
right there.
connects up to this. Ooh. That oh god, that is like okay.
Yeah.
I know he had a lot. I didn't know he had that much.
Yeah. But here's the thing. The first entry, and like I said, this is only Athens, Clark County. Other counties in Georgia, other states, I have no idea. I have not been able to find.
Yeah, I don't know.
Any...
I don't know if he's only ever been in Clark County or if he's been other places. But
however, in Clark County, this is where I find it from a psychological perspective fascinating. And none of his convictions or charges or anything have happened until after 2001.
Yep.
The first one was 2004. And that was via, well, yeah, there's got to be more.
He was arrested. He was arrested in 2001, but it was after the crime, like February when he was arrested.
Yeah, because his there's the filing dates are all. I have to go by the filing dates. Oh, and this is what happens when you. So this is just Superior Court. So if we want to go to all courts. So.
That is a lot.
And I'm just making sure this is all him. There's 2 pages, but whenever I click on the second page, it goes back to this. So I don't know what's on that second page. However, that the unaliving trial is on the second page because it's not on this. This is where it's fascinating.
He was convicted for the February 1st assault, poking a man in the neck.
And this is where I really hate that. This is where this is where Clark County's website really gets a little annoying because I don't have a login and I'm just using the public part. That it gets very touchy.
It's not like what people say Fulton County is easy to navigate their website. Like,
yeah, it's easy to navigate if it works, but like links are broken. Oh, there now it works.
Okay.
Oh, look at that.
Just needed
look at that.
Just needed a few minutes to reset it.
Just needed a. Just needed. What the heck? That's not normal. Yeah, I don't know what's happening here. Either way, this is all him.
Sheesh.
A lot of it is probation violations.
Yeah.
So.
Yeah, a lot of it don't have nothing to do with like assaults.
A lot of it is booger sugar.
I think there's a couple of possessions of narcotics in there. And...
driving while license is suspended. Nothing that would lead me to believe that he would. Nothing violent. However, this was after he is accused of. Yeah, that is true.
Edrick has
He's
been it could
2019, 2020.
Oh wow.
2019 2 different times.
So wouldn't that be like a conflict of interest? I don't know how judges are selected, but you would think it was try to select a different judge for him since he heard his stuff.
The judges that he's been in front of. Look, these are all the judges right here.
Yeah, no, I know. But I'm going to like the comment when it's like when I don't know how to pronounce the name. Edrick had been before Judge Mott before. All right, wouldn't you think they would give him another judge since he heard some of his stuff before?
Possibly, but at the same time, judges are supposed to be impartial. So, you know, yeah. In theory, sorry.
That might be something I would have brought up in the motion to recuse.
Driving while license suspended, fourth time. It's just like, but none of these say violent. Yeah. However, psychologically speaking, if he had no prior criminal record before that and did that crime that he's being accused of now, and then all of a sudden it broke him and he couldn't handle it anymore, and that's when he's now all of a sudden he's, you know what I mean?
Yeah.
I mean, because if you had no criminal record before this and all of a sudden you did something and for whatever reason that it was done, and this is hypothetical, he is innocent until proven guilty.
And none of these
However,
convictions are going to come before the jury. Too prejudicial.
but it's violation of probation, sale of booger sugar. Sorry, it's what I call it. It's either that or so Dose Reality. Dose Reality had a video the other day talking about the what the hell stuff, and she said she was talking about somebody, and she was like, Florida snow, or the only type of snow you're ever going to see in Florida. And that like I lost it. Like I was listening to it when I was like brushing my teeth or something, and I like spit everywhere, and I'm like, oh god. I laughed way too hard at that. Chris Melton's criminal history would be interesting if he has one. Chris Melton.
He's
That's the boyfriend.
Tara Baker, the one that Cruz and them was saying it's the real culprit.
Yeah, the boyfriend. Or the boyfriend at the time, or the ex-boyfriend.
Yeah.
I get.
I think you're the boyfriend.
This is where I sit and I work with documents because my brain cannot. My brain cannot handle things that like. Yeah, I do better with reading things than I do with hearing things. So if I see it, I'm more likely to remember it when I hear stuff. And that's what makes, like, it didn't get me out of jury. That being a stay-at-home parent was what got me out of jury duty.
Interesting enough, it's funny, this case, they have a doctor on the jury. I'm like, that is shocking to me.
Well, hey, Andrea. Having a doctor on the jury wouldn't necessarily be like a bad thing. It's having like her doctor on the jury that would be a problem.
Or your judge.
Yeah. Like having a lawyer on the like now I'm really not sure because the little was like super little when I got my jury duty summons to the point where when I went to go put my go to the courthouse to file my like paperwork for to be excused, the clerk of court was like, I'll watch her, and I'm like but now it didn't work for Mo it didn't work for Mo when she had jury duty in Indiana. Remember that not last year but maybe the year before when she had jury duty. But now I'm wondering if I had jury duty and I showed up and they were to vaudire me and they were like, well, what do you do for a living? I'm like, well, I follow court cases on YouTube and I read legal documents for a living. What they'd say.
Yeah, that is a good thing. Cause I wonder what would happen to somebody in jury like somebody, well, do you know about Frank? Like, yeah, I know about it. I watch Long Crime in Court TV. Like, oh.
So I found one booking for Chris Melton, failure to appear for fingerprintable charge, which was a misdemeanor.
Yeah, she did.
Well,
she mentioned the court.
Dad, the thing that is weird to me is I cannot find any criminal history in this county, or I can't find any criminal history. This county is specific, but before this crime that he's being accused of right now, which is fascinating to me from a psychological standpoint of if he really did this, having no prior criminal history. But see, if he did have no prior criminal history, if I was his defense attorney, I'd be bringing that up. He has a criminal history now, but he had no criminal history at the time.
The thing about it, they wouldn't bring that up because none of his convictions would come before the jury anyway, because that automatically implied guilt. If a jury, they're like, well, he was convicted.
Well,
so
yeah.
obviously he could have done this.
Well, that's the thing. That's the thing about a cold case. Prior bad acts would have to be prior to the commission of that particular crime, which would be 2000.
Yeah.
Because this was January of 2021 or January of 2001.
Yeah.
So this would have to be
2000 or something.
2000.
90s or something like that.
Yeah. So, that was in Lee County Jail in 2025.
Yeah, that's Chris Milton. So that was
yeah.
Yeah, I
agree. Tree, I agree with this. Judge calling the jurors by name in court is weird, especially when the trial is streamed.
I forgot to tell y'all. A witness was testifying, and that's not even on judge. That's on court TV and Long Crime. Whoever had the pool camera, they published somebody's social security number.
Oh my god,
I'd
be
what you doing?
I'd be suing
Then they started
because that
like,
truly is like breach of personal information. So he's got probation violation for a felony. There's the probation violations. Like I have no criminal record at all, but if I did, I think that I'd be like minding my P's and Q's, and a probation violation would not be my I would not want to get in trouble again.
yeah. Huh, I got
So
this
this is
on YouTube. I got to figure out something to do for YouTube now.
well, they found it through codicid. I think the judge will let previous bad acts in. Well, I have a question though. The previous bad acts, because this is a cold case, it's not like Laura Owens, that the previous bad act kind of has the same MO as the current bad act, or a Colin Griffith in Florida, where he is accused of, or he was acquitted of unaliving his mother in self-defense, but he had unalived his father in self-defense in a different state the year prior. This is 20 years or 23 years between the time that the crime was committed and when he was arrested. So would prior bad acts, and this is where me not being an attorney and me definitely not following cold cases very much, and on this channel, I literally just ask questions. I never claim to have all the information. I just ask questions because this is how my brain works.
Yeah.
Would prior bad acts be anything before the trial, or would prior bad acts be anything before the crime that he's being accused of was committed? Because anything after the crime really shouldn't count, because that has nothing to do with the commission of the crime, other than maybe he couldn't psychologically handle the fact that he unalived somebody and he went off the deep end, which is a real possibility.
Maybe it'd be
a real
important.
possibility.
I'm trying to remember what opening statement. Maybe we should at some point watch like the openings.
Yeah, and for those of you who are joining from Nick, I have not been able to stream or watch every second of this trial. However, FlashFan has been streaming it on his Discord, which is pinned to the top of the chat.
We go
I
Monday
have
through Friday,
been
11
covering
p.m. Eastern till 5 p.m. Eastern when they get out of court, or when they supposed to get out of court. Let's get they have like motions or whatever.
quote unquote. I've been
Dalbert the other day.
I've been covering other things this week. We still have the Tyler Robinson hearing to cover. Oh, I still haven't even gotten to the Derek Rosa sentencing hearing. And yeah, we still haven't gotten to that. Like, that was 2 weeks ago, 3 weeks ago now. Then there's I need to give updates on Sharon Moore, the former Michigan coach.
Oh, yeah.
So he had his probable cause hearing. Do you know which judge his probable cause hearing was in front of?
That's Michigan, right?
Yeah.
Simpson.
Yep. Yes. So so we still have to watch, because I love, and for those of you who are new to my channel, I love sports, and I love where sports and the law meet. We still have out of this same county, UGA is suing a former football player for the University of Georgia who now plays for Missouri for mandatory arbitration for an NIL contract breach for like $300,000, because he signed an NIL contract and then transferred a month later.
Yeesh.
We have his response to get through. That's 128 pages. Like, I have so much stuff right now that I'm like, and then my whole second channel that I'm just so like streaming this trial was just
Yeah, you got a whole bunch of content. Especially they talking about Cruz is talking about 4 to 6 weeks. I'm like, whoo.
Can you be a phone? Mommy? Angel? You want mommy's phone? No. Pat. It's over there. You're welcome. I love you. Oh. And then, I am a full-time stay-at-home mom, technically speaking. So this is all his stuff, but I'm not seeing any, it's mostly probation. I'm not seeing really any of, oh, here we go. Terroristic threats and acts in September of 2018, but he pled guilty. 120 days confinement. So, I don't know. Terroristic threats. I mean, that would be sort of violent.
Yeah.
Aggravated stalking. Violate family violence order. Harassing phone calls. Okay, here's where we're starting to get a little.
Yeah, Faust is definitely no saint.
Yeah, well, yeah, not that serious if he is only 120 days. Little voice, so cute. Yeah, she has her moments. No, she's a good kid. She's a great kid. So this terroristic threats was let's see. The arrest warrant. And this stream is kind of like where we don't really have we have a plan, but it's not really like we're just going where the wind takes us.
Yeah. Not like out there, like hit this point of this task that the 1 hour mark. We on this document.
Yeah. Aggravated assault. Did place his wife Sabrina Faust in a reasonable apprehension of immediately receiving violent injury with a pew-pew.
Oh.
To wit, by pointing the gun at her, saying, "I will unalive all of us."
Woo, okay.
Okay. And he was so with that.
You got 120 days for that?
That's all he got was 120 days for that. Well, he pled guilty. So
Yeah.
he pled guilty. So he pled guilty.
Yeah.
So there's that.
I guess that the judge factored in him taking responsibility.
So if you plead guilty, there's definitely
Now a plea deal was offered to Faust and the kid. I've got the minute. I found that yesterday. The plea deal was life in prison. But
is that really a plea?
Yeah, he waived all life in prison with the possibility of parole, waived all appeals. I think he was off like a month before trial. And obviously he turned it down because they in trial.
Yeah. But if you are this is all the stuff from this
That's definitely not sweet.
State's plea offer.
Okay, yep.
Malice murder so it looks like you plead to malice unaliving.
That's not.
I can say the M word, but I can only say it so many times within a.
That's not right. That's not pleading guilty to malice is not right because that's like pleading guilty to first degree.
Yeah, that's Georgia's. I mean, basically, that's comparable in my estimation to like Wisconsin's first degree.
Yeah. Their malice. They call it their malice. That's essentially just first degree because they're the case in court from the 90s, and he was charged with malice, and they charged him. They had him tried him for the death penalty.
Let me look. I should have not done what I just did. I don't think she was. I think it was Regina Quick. Unalive.
We're not gonna see been a judge.
So
I
we're
know-
just gonna go.
I know she just became the chief judge in May of last year, or maybe May 2024.
I think all of hers were the probation violations. But I could be wrong. Because I'm open to being wrong because, I don't claim to be perfect or right all the time because, Oh, it was the aggravated stalking was her.
Oh, okay.
Probation violation. The aggravated stalking. No, the terroristic threats were Regina Quick,
Okay.
Judge Regina Quick, but the aggravated and there's no way for me to make this page bigger for you guys. I'm sorry. The aggravated stalking, violating a family violence order, and harassing phone calls where he pled guilty to all of those too. That was Judge Lott. So yeah, that was Judge Lott. So in a lot of his probation violations have been her. So she's familiar with
That's why they maybe
defendant.
should, out of abundance of caution. I won't go to stress saying that she's biased yet, but I'm like, that out of abundance of caution, everybody, yeah, we maybe need a new judge that he hasn't been before yet.
Well, here's the thing. With a record like his, he's been in front of
Probably all of them.
everyone.
Yeah.
Kent Lawrence, Charles Auslander, which I believe was the judge for
Ibarra?
Ibarra.
Okay.
Simpson,
Oh, they got a judge.
Stevens, Sweat, Regina Quick, Lisa Lott, Ryan Hope, Joseph Gaines, David Sweat.
Judge Sweat. That's interesting.
So he's been in front of numerous.
Yeah, probably not. I don't know how big. I think I read somewhere where they say Athens Clark County is small, so that's probably like all the judges.
Yeah, and this is one of the reasons that we have to watch the latest Tyler Robinson hearing, because I think that's an issue in his trial too, or his case too, is DNA science that is new and is.
And I do remember this like, that's one of the like, that's a bit of a stretch when she met that in.
And I am all for advancing of science. However, what happens if you're wrong? Like, say, Stephen Avery, for example. Stephen Avery was, y'all know Stephen Avery from the Teresa Halbach case. A girl
out there, but they don't.
So, the girl I worked with that like hated me apparently, that like still I live rent free in her head to this day.
We talked about her.
Yeah. Well, her husband and Teresa Halbach's brother were roommates in college.
Oh wow.
Well, with that, Stephen Avery, this is where the fascinating, the sense of the psychology of making a murderer comes in, because Stephen Avery spent 26 years, I want to say, he got the Rip Van Winkle treatment, in prison for a crime he didn't commit and was released based on DNA. But did those 26 years or whatever he spent behind bars create a criminal where there otherwise would not have been? Because he was wrongly accused and wrongly convicted, did someone who was not originally a criminal, did we predispose them to being a criminal because they were behind bars with people who actually did commit violent crimes?
Yeah.
getting exposed to that for 20 years plus.
And the crazy
Then
part
when they
was
get out,
even Avery wrongfully convicted in that case that he spent 18 years for. So I'm like,
yeah, 18 years. Yeah, and that's where I'm like, that's where the psychology of, well, I believe that he did all the police stuff. I believe they were a little shady, but at the same time, I kind of believe that he did it.
okay.
With that being said, would he have done it? And would he have been that kind of a person had he not spent 18 years behind prison? So is it the state's fault, basically?
Yeah.
And that's where my brain goes to the psychology and predisposing people to situations and fucking things up when we shouldn't have. You know what I mean? That's where my brain like gets very fascinated. And
I think you definitely have to be like careful with when you charge people. Be like, it did because just because they committed a crime, like, oh, he's like they done it. This I'm like, I don't know.
yeah, and just because you are a crappy person doesn't mean you are a unaliver.
Yeah.
You might be a very shitty human being, but just because you're a very shitty human being doesn't make you a person who will unalive somebody else. Like, is this somebody that I'd want to go out and have a drink with at night? No. Is
Just
this
like,
somebody I'd want to consider a friend?
I hear a lot
No.
of people say that about Karen Reed. They like the people. They like, well, Karen Reed doesn't seem like a likable person. I want to hang out with her, but I don't think she's guilty.
Yeah, you don't have to be a likable person to, like, I don't have to like your personality to be on your side. Like, the facts. Like, you don't, and that's where I think people get emotional and wanna like, yeah. Yeah, certain vulnerable and impressionable people could definitely be made to commit crime by being around other criminals.
Yeah.
And that's kind of the issue. However, we've been at this for 3 hours and I gotta get going. Because I have had this to eat all day
Ooh,
and I'm getting hungry.
you gotta get
So
some.
I appreciate all y'all being here. I really do. We are going to see where we can redirect you. Right now the little probably bumped her head on something, or she is crying. So dad, or check DMs. Okay, checking DMs. Oh, there we go. Sweet. All right, hold on. Let's see. Let's. Come on, come up. So I'm trying to redirect to Snipe Hunter, and he's not coming up on my redirects. So if y'all want to put up Heidel, do you want to put up his link? There we go. In 1 hour, Snipe Hunter will be live, so go check him out. But I cannot find his it's not coming up when I search for videos. So tell him with best of intentions, I tried. I really did, because he's awesome. And I like to support people who, are my friends and support me. However, with that being said, J-Hip is live. So for a little bit until Snipe Hunter starts, just J-Hip is live. And go say hi to him and tell him I sent you. Thanks for hanging out. I appreciate you. It's good to see you. Y'all have a great day, and I will see you tomorrow on my other channel. We are talking the 5 do's and don'ts for rib fractures. Because people around here like to break their ribs, and they like to tell me about it and freak me out. So we're doing these 5 do's and 5 don'ts for rib fractures.
You the unofficial doctor.
I'm not a doctor. I am an occupational therapy assistant, a certified lymphedema therapist, and a corrective exercise specialist. However, none of those apply specifically to your situation. So take what I say as general knowledge. I am not a I am not just because I'm a coda doesn't mean I'm your coda. So everything is general education. However, people keep breaking their ribs and their doctors are telling them, have a nice day, grin and bear it. So we are doing some exercises to help with that. The 5 do's and the 5 don'ts of rehabbing rib fractures at home. When rehab tells you to have fun and do it on your own, that's where I come in. And then Monday we have these Monday we have since I was called a felon for reading court documents in an attempt to intimidate. Oh yeah, Lips called me a felon for reading practicing law without a license for reading court documents. Oh, gotta add you to the stream. There we go. For reading court documents. So when somebody, legally Lips, puts all of her dirty laundry in the public sphere by filing frivolous lawsuits against her family members, like her mother, when she puts all her dirty laundry in court documents, we are going to read the shit stains that she puts in those court documents. So we have been reading her Lips versus the Florida Bar when she sued the Florida Bar in 2023. So we're going through.
That didn't go well for her.
Well, when you call me a felon, that is by definition defamation. However, I can't sue her because she has nothing. She has 2 houses in foreclosure and literally has no job. So instead of wasting the time and money suing her, I am just going to take whatever she has left of her dignity and make content out of it every Monday from now until 2027.
And exposure, yep.
So with that being said, I am that petty. So Petty Mondays, Lips versus the world, Lips versus the Florida Bar.
You clean at a petty version, ladies and gentlemen.
Some people have called me the sweetest person on earth, and other people have called me human trash and evil, and both are right. You just have to get it depends on which person you decide to attack. And when you call me a felon for reading publicly available documents while telling you that I am not a lawyer, I will make content out of you until 2027. So if you want to get in on the petty, join me Monday at 2 p.m. I will see you guys on the next one. Have a great day.
Bye, everyone.
Bye.